Boom. Hey, folks. Maybe we should have some light. How's everyone doing? I hope everyone's having a wonderful Monday. It's a little bit of a slow start because I was like, all right, ready to go. Oh, I really should hit the washroom first. And then I recognized that Potter was outside, and I was like, oh, I guess he should come in because he's outside and Mrs. Runkle's not here at the moment. So I was like, all right. Yeah. So I had to fight with that. Um, I see this is a starting question. I know it's off topic, but have you heard about the Discord ID requirement? I have. They may run into privacy issues in various jurisdictions on that, but the other thing is that I suspect that ID requirement is going to be easy to bypass, and I can say that I may have already ordered something for the express purpose of messing with the Discord thing. So, I will show you when it arrives and when it's time to make the video of it and so forth. The time for me to actually do the test, but yeah. What is it? Please let us see Potter before he goes to sleep. Potter is not super inclined towards being on the camera. Somebody said, is the Discord ID requirements everywhere or certain countries? They've said everywhere, which is dumb. So yeah. Can I post my Discord? Yes. Give me a second. I can get the link. Here's a Discord link. We'll just drop that in the chat. There we go. All right. So today we've got a few things to talk about. So one of the things we'll be talking about is the Faust trial. Now, I'm not doing sort of recaps of the Faust trial, mostly because by the time I started getting interested in it, it was already like halfway along. But we are going to be doing some discussion of the Faust trial, including some watching of stuff. So that'll be kind of a where we can, as we can, where it becomes. So some days we won't talk about it all because they're just, how do I put it? Some days are going to be super boring and super uninteresting and whatever else. And some days are going to be more interesting. And today's one of the more interesting days because the defense's theory is basically entirely pointing the finger at the previous boyfriend, right? They're like, hey, it might not have been, this guy. It might have been this previous boyfriend, Chris Melton. So the prosecution is calling Melton to the stand. They are bringing him on as a and so the prosecution basically brings him on to be like, you didn't murder your girlfriend, did you? And he's like, nah, I did not. So, which of course is what he's going to say, right? The key thing there is going to be on the cross. So I'm not going to pay a whole lot of attention to the direct because you already know what the direct is going to be, right? It's going to be, did you murder? No, I did not murder. No murdering. Because it is almost unheard of that somebody gets up on the stand to say, yes, murder. I did the murders. You see this kind of thing on, you see this in like TV dramas where they have like Matlock and so forth, where, they're like, hey, and they'll have Matlock cross-examine the guy so thoroughly that he ends up being like, stop, I did the murder. It never happens in the real world, right? The real world just does not include any of that. It just doesn't, right? That's not how that works. It's not how it happens. It just So those kinds of moments you basically never see in the real world. Instead, what you see is people fall apart a bit. People, people start contradicting themselves. This kind of thing, right? And yeah. All right. So let's we're going to look at part of the direct, not a lot of the direct, because there's one part of the direct I do want to go to, and that is kind of a critical element there. So, all right, let's go. I think it's it's right about here, and I have a statement. A friend who wants to try writing an opening statement for fiction. Ooh, any recommendation to good ones to reference? Ties into your advocacy through public files talk. I'm just trying to think. I mean, if you want a showy one, you could start with the Karen Reed was framed from the first Reed trial, if you want it to be showy. I'm just trying to think. I seem to recall that the opening statement was okay in Rittenhouse, that it was also okay in. Now I'm going to have to think about that. So let me get back to you on that one. Okay, I should also set a goal, because of course I should set a goal. All right. All right, there's my goal. It's going to be a little bit cheeky because that's kind of how I roll. All right, so this is the part of the direct that I thought is most critical, most key, and we're going to jump there. Other things that are on the docket today, we're going to talk a little bit about robot lawyers. There's been some really interesting robot lawyer news, and so we're going to talk a bit about that. We're also going to talk about WestJet. WestJet fired a pilot, and they fired the pilot for really good reasons. And then they were told by a tribunal that they had improperly fired the pilot, that they shouldn't have fired him. And then that went to the Federal Court of Appeal, who is like, let's talk about this because this is some shit. So yeah. Wait, what? Has he talked about Law and Crime taking over Court TV? Law and Crime is taking over Court TV? What? I had not heard. So yeah. Also, if you are yeah, so we'll talk about all of those things, and yeah. Okay, so somebody says hoping Melton is first. Melton is first. Let's jump to Melton. All right. And I'm going to just go right here. Here we go.
To the apartment to grab a few things.
Well, let me ask you this, Mr. Melton. How do you typically deal with very stressful situations with difficult emotions involved?
Traditionally, I bottle it up.
I mean, that's a really shit question, but you know where they're trying to go somewhere specifically with that. And, but we're going to talk about why this is such an own goal for the prosecution. And this does not go well for the prosecution at all. Oh, wow. A friend's sister was Tara's law locker buddy. She's still rattled. Wow.
Traditionally, I bottle it up inside, and I bottle it up inside and try to hold a secure presence for myself and the people around me. And yes, sir.
Now, I'm just going to say a lot of people do actually I say a lot of people. a lot of guys specifically have the coping strategy of just bottling it up. It's not the most healthy coping strategy, but this is part of the problems with our this is part of the problems with how our society works, and especially there's not a lot of like good resources for guys who are having a time. But this set of answers really doesn't go well, because let's keep going.
What happened on that day on January 20th, the day after Tara's murder, once you got inside of your apartment, townhome, however you want to describe it?
Once we entered my apartment, my parents were with me, and I started having an extreme emotional moment. And they recognized that it was hard for me to hold it in any longer. And I do recall my parents coming to me and wrapping their arms around me and trying to get me to calm down. And in that moment, I actually felt claustrophobic. I felt restraint. And I remember pulling away from my father to get away from him. And then I spun around, and there was a wall in front of me at the bottom of the stairwell. And it was the sheetrock wall. And I just remember unleashing my emotions on the sheetrock wall.
Oh, so you're the sort of person who loses his temper and starts throwing hands at a wall, huh? Huh? Like, they're trying, the reason why they're saying this is because they're trying to explain a real bad problem that they have, which is the defense has already shown pictures of this dude's hands, and that those pictures show, all sorts of cuts and bruising and so forth. And I'm going, okay, all right. So your explanation for the cuts and bruising is you lose you lose control of your emotions, and you just need to hit something. Unfortunately, I have too much pop left in this because there we go. That's the sound it needed. That's the sound effect that was necessary there. I'm just like, you are the alternate theory. And the alternate theory that the jury is probably assembling in their head right now is that this guy went over, him and his girl were having some difficulties, some whatever else, that he went over there. She said, hey, I've been, I've been sleeping with some other dude. And he loses his temper, attacks her, right? And if you're trying to say this guy is not the this guy's not the dude, showing the jury that he loses his temper like this is not a great start. But I mean, that's what they got to do, right? That's how they've got to try to explain the explain the damage. Now, this also means that his parents are probably going to testify and all of that. Ashy, I'm late. Did Runkle complain about monetization already? Not yet, but thank you.
And I punched it, I don't know, maybe 30 times, maybe more.
Did that do any damage to that wall?
Oh, yes, sir.
Did it do any damage to your hands?
Yes, sir.
Okay. Good. What kind of damage did it do to your hands?
It scratched my hands up. It swole my hands up. Fortunately, I didn't break anything, and I guess fortunately, I didn't find a stud in the wall. It was mainly sheetrock, and as I went through the sheetrock, I was finding, I believe it was the concrete siding on the outside. It was an exterior wall, so I was punching through the sheetrock and hitting the concrete siding to the outside, and I was knocking, to my knowledge, I was knocking the siding loose also.
Okay. The next day, that's January 20th of 2001, after you stopped at your, townhouse apartment, whatever you want to call it, at Jamestown, where did you and your parents go after that?
We went back to my parents' house.
Okay. So on the 21st, did you speak with law enforcement again on that day?
Yes, sir.
Okay. And what is it that you were going back to speak with them about and do?
I believe to answer further questions. At that point, they were asking for further information to my knowledge.
Okay.
And once I got there, we had discussed blood work and other, blood work and other things that may be needed.
All right. So then they have him say, and I was super cooperative with the police because I am an innocent person, and being super cooperative with the police is what innocent people do. Okay. So that's kind of his whole thing, right? So all right. Let me just find the beginning of Cross here. So some of my timestamps got messed up, and here's how they got messed up. So I was watching this on Law and Crime, and then Law and Crime had some streaming issues. So Law and Crime cut their stream in half and restarted the stream, which ended up erasing all of the previous stream from being online. So had to start over. But that messed with my timestamps because the other thing doesn't have the right times. So yeah. Oh, right. Let's talk about this. Let's talk about this moment. This is not the moment, but this is not the beginning of Cross, but it is a moment that I was just like, I was watching this and it did not play well for me. And so I wanted to share it with you just to see if it plays well with you, or if you're like, hey, this is some bullshit. So
Feelings that I was getting.
You testified earlier about having a tendency to bottle up your emotions. How were you doing emotionally during that time period?
I'm struggling. I am struggling. I daily I have to put on the best way I could describe as a facade to make it through the day. I understand that I have to make it through daily, but at night or whenever things stop, such as work or things that can keep me sidetracked, especially the nights were horrible. I would find myself on my knees, pounding the ground, the sand, whatever, just just finding myself so mad at God that I couldn't understand. And I would wake up so many times for the longest time in the fetal position where I just cried myself to exhaustion. But every day, each time I would be so angry and find myself in this position. As mad as I was and not understanding how God.
I'm just going to comment on what you aren't seeing here. What you don't see him do. You know what he doesn't do right now? Doesn't reach for a tissue. And that made me go like, what? Because normally during a lot of this stuff, when somebody's actually breaking down, you can't really help it, right? Your eyes start watering, your nose starts running, but he's trying. He's trying real hard. I don't know. Some people said they were moved by this. I did not feel this. And I thought if I'm on the jury, I am going, whoo. Yeah.
It could allow the devil and his angels' house. I would feel warmth and thoughts in my head that weren't my own, telling me not to give up, not to give in. And it gave me the strength to get up each time and strap on my boots and carry on through the day. And this cycle continued.
And the Oscar goes to literally anyone the fuck else, because I am not buying it. Yeah. But we hit the goal. So the thing is, when people are actually when they're in a full-on cry, sometimes they have to force the words out in between crying, but he's not actually doing the sobbing thing that would have you needing to force out the words and have that halting thing. But he's certainly trying to ape it.
For a long time, until I just couldn't recall certain things and it would fade. But through the days, I would just find a way to make it through and keep my mind occupied, and just dread of the next night to come. And it was so difficult. But I found a way. Jesus helped me get through this.
And I just also, sorry, religious people, I may piss you off here, but when I hear somebody on the stand start talking about Jesus, and I do criminal defense, right? So when I see a witness start talking about Jesus, usually that person is a lying sack of shit. And I mean, not always. There are some people who are very religious and so forth. You occasionally, but like this guy is this does not feel like that, right? And I mean, how do I put this? Sometimes you get the witnesses who they mention Jesus, but they don't mention Jesus to like back up their shit, if that makes sense. They mention it because like I had a witness who was on the stand, and the it wasn't I wasn't cross-examining, it was the prosecutor's witness, but the prosecutor was asking this person what they did, and the person said, well, it was a Sunday morning, so I started off going to church because I found Jesus later in life, and Jesus is really important to me. And then they went on to tell the rest of their story. And that I didn't find super deceptive, because it was just a person saying like, this was part of my day and whatever else. It's when the Jesus starts to come out at critical moments, right? When it starts to come out in the moments, that's when I'm like, ugh. And the thing is, it's a risky move, because ultimately people throw in religion in these moments because they think that it's going to get the jury on side. But in my experience, if the I see somebody saying, can we turn up the court volume? We can. I'll just have to do that. In my experience, if you've got somebody who has honest, genuine religious faith, and they run into somebody who starts throwing around, like the Jesus this, Jesus that, in order to get out of shit, they like genuinely religious people will get even more upset about it than I do, right? Like, I'm just like, this is kind of gross. Some other people are just like, I am mad. And I mean, if you knew that this guy was going to go this direction, this might be a place where if you'd had the time to hire a private investigator, it might be worth having a private investigator see where this guy goes on Sundays. Because if this guy had done this in like a preliminary hearing or a grand jury hearing or something like that, I might see where he is every Sunday and just go, hey, can you find out where this guy's church is? I want to know some things. Because, when you get the guys going, I'm, it's like, all right, which church do you go to? You said Jesus has saved you. He's very important in your life. Which church? How come they don't know you there? These kinds of things, right? So
Carry forward.
Mr. Melton,
Sir.
Mr. Melton, I'm going to ask you, sir,
and he looks up, and those eyes are dry as a fucking bone. You could dry your hands on his eyeballs, and I don't see any moisture. I don't see any redness. I don't see any difference than he looked 20 minutes ago.
law enforcement continue to reach out to you at certain times during the investigation?
Yes, sir.
Okay.
Man, your sobbing stopped real fast, didn't it?
When they reached out to you, would they ask you for things or ask you questions, or what would they talk to you about?
Just different things. I I'm sorry, it's hard for me to get my thoughts together at the moment.
Well, that's okay. Let me ask you this.
That's my recollection.
All right.
If I, this is,
My question is when? When did they tell you?
I jumped a little ahead. Too far ahead.
Mr. Melton, thank you very much. I don't have any other questions for you right now.
There we go.
Cross-examination, Mr. Cruz.
Good morning, Mr. Melton. My name is Attorney Amai Cruz. I have the privilege and honor of representing Mr. Faust. And under the authority of this court, I'm going to ask you some questions, okay?
certainly.
Okay.
I was already like, wait, what's he doing? I don't really like this intro. He's already told the jury, like, I have the privilege of representing Mr. Faust. Okay, cool. Jury knows it, and he ends up saying this like 6 times today because he cross-examines a bunch of witnesses. But under the authority of this court, I'm going to ask some questions. I'm like, man, that's freaking clumsy. I don't know. I don't know why he's doing it. I just thought that was a bit of a weird, weak intro. So,
Why didn't you cry?
but that I went, oh. Normally you build up to that. My philosophy is always that you start off with the gentle cross when possible, and then you can go to the harsher cross afterwards. Why didn't you cry is not the gentle cross. Why didn't you cry is like, we're fighting. Like, we are gonna fight. we are gonna fight is basically what this comes down to. And the thing is that generally you want to you don't want to do this unless the jury's there first. And so if we assume that Cruz has gotten to is looking over at the jury and is doing his job well, he thinks the jury already hates this guy. Like, he's made that tactical determination. He's like, jury is already at fuck this guy, and so we're just gonna go on the fuck this guy train. But yeah, that I was like, oh, okay.
Okay.
Certainly.
Okay. Why didn't you cry
When?
just now? Why didn't any tears fall out of your eyes?
They are falling down.
They are falling down. I'd have been like, do you want a tissue? Because
Well, let's talk about January 19th. Would you agree that today you were much...
I actually thought that was a very I thought that was a spicy start. I thought that actually was a spicy start that did pretty well, because he's like, they are falling down. It's like, are they though? Like, really? Because I ain't seeing it. Yeah, I mean, sometimes you want to start a witness off by, like, kicking the tires and putting them a little nervous, and that's what he's done here. The thing is, the problem with that is that you put the guy on the defensive and you get him and he might not answer questions as openly as he would if he otherwise. So yeah,
more emotional than you were on the day that you learned of Miss Baker's death.
I was holding it together best I could.
So your borderline fiance is murdered and you were holding it together on the 19th, but 25 years later, you have emotion about it?
In that moment, when I'm finding this out,
Mr. Melton, that's a yes or no question.
Judge, the witness is allowed to answer Mr. Cruz's question.
That's correct.
The prosecutor is actually right here. You can ask a yes or no question, but that doesn't mean that the witness has to answer yes or no, so long as they're actually responding in a responsive way, right? So, if somebody asks you, did you have cereal for breakfast today, yes or no? You could say, I had a grapefruit. And it'd be like, the guy's like, I said yes or no. It's like, I said I had a grapefruit. That's actually a responsive answer, right? I had a grapefruit. You don't necessarily have to answer the yes or no. So defense is trying to box him in. Prosecution is trying to keep him unboxed, if that makes sense.
When this tragedy occurred, and I'm taking this information in, I am telling myself inside, do not collapse in this moment. Hold it together. There are other people that are also relying on you. And I had to get through this. And that's where I'm at.
Who was relying on you during your initial interview with police?
The police, her family, her friends, anyone who loved her.
So the police were relying on you to hold it together during the interview.
If I'm not holding it together, I can't think things through.
Sure. Did you know that your DNA was found in Miss Baker's anus?
This is not a gentle cross at all. Like, this is what, like, his third or fourth question? Sometimes cross-examination is like dating. You don't get to the DNA in the anus on, like, the third or fourth date. Wow. I don't know if this is, I don't know if this is how I would have done this at all, but yeah. Okay, he's just going hard.
I was informed.
Who told you that?
Liz and Jeremy from the GBI.
When did they tell you that? Because in the recorded interview that we have, they didn't mention that to you.
That's my recollection.
My question is when? When did they tell you?
If that's not the correct recollection, I'm not sure at this moment.
And we're going to speed it up to
Let me ask you this.
1.25.
When was the last time you met with the state?
This morning,
Okay. And they talked to you about your testimony?
we went over what the courtroom would be like.
Okay. So this is rehearsed. Is that fair to say?
I wouldn't say rehearsed.
But you went over it not just this morning. You went over it a couple of times last week. Is that right?
We have established a process in which would occur in this courtroom as far as steps that are taken once I get here and whatnot.
Okay. So the questions that you were asked today, you already knew you were going to be asked those questions, correct?
Yes.
Mr. Melton, I am going to...
Can I say something to this?
That's
Thank you, ma'am.
No, you cannot just narratively say something. You've got to answer questions. That's how this works. You don't just get to, I got thoughts.
Mr. Melton, would you like a slim marker or a big marker?
I did not like the writing thing that he does, right? He does the writing thing, and I don't like it. I think it's, I don't know. I thought this was a little bit, I thought this was a little bit stupid, the way he's doing this. And if I was the court, I'd be like, you can't. Sorry. But at the same time, I kind of like the moment where he's like, you know, he's got this guy, he's got the guy kind of battered around, then he's like, slim marker or a thin marker? And the guy's like, what? Slim marker or, you know, thick marker or thin marker? And it's like, the guy doesn't even know how to answer that question. Watch this again. It's fun.
Mr. Melton, would you like a slim marker or a big marker?
Slim.
He's just like, huh? What? Yeah.
All right. Let the record reflect that I am going to give you a black Sharpie, okay? I'd like you to write the very first time that you mentioned during your direct examination in regards to your actions or where you went on January 19, 2001. Do you understand that?
Yes.
May I approach the witness, Your Honor?
May.
Can you please write the first place you went on January 19th on that board there?
And Your Honor, I would ask that if Mr. Cruz is going to ask the witness to engage in whatever this is, that be repositioned to a place where the jury can actually see it.
I can do that.
If he's going to ask him to engage in whatever the hell this is, I'm like, I get it. I would have objected to, this because what he's doing is he's making him do some like arts and crafts and so forth. But he's basically like generating exhibits for the jury to look at later. So, yeah, here we go.
We'll start on page 2.
We'd like to also be able to see it. I guess, Judge, do you want us to move or do you
No, I
want
think-
him to move it over there?
Mr. Cruz, I think perhaps moving that back would be best for everyone to take a look at it. Thank you, Mr. Hill.
Sure.
The prosecutor's like, yeah, we also have to see it. Everybody's got to see this. And I'm just like, this is such a fun little, I'm surprised the prosecutor isn't going, can he explain what he's doing here? And also, no, this is not how I would have done it. This is not how I would have done this cross-examination. But Cruz is actually doing, he's doing pretty good. I kind of like him.
You may proceed.
Sure. Can you write the first place you went and the time that you went to that location? Okay. So I want to make sure I'm correct. You wrote Nash Plumbing 7:30 to 7:45. Okay. So you remember from January 19, 2001, you went to Nash Plumbing between those times. Is that fair to say? Okay, but you could not remember when law enforcement asked you if you knew Ms. Baker was going to be alone in 2006? You can take a seat, Mr. Melton.
Like, that's all he wanted him to write was Nash Plumbing. It's like, oh, okay. Because at this point, I was watching this and going, I don't know what he's doing here. I don't know where he's going. it actually works out pretty well for him. But I was watching this whole thing going like, what is he doing? Where's he going? Where's he? Yeah.
Along the way, I'm questioned about certain things, and I pull up my best recollection. Post this, I've been traumatized. I'm grieving. My mind is certain things and certain times. It's hard to pull from.
Law and crime. You desperately need somebody who can master like the zoom and focus, because they struggle with that a bunch here.
And in those moments, stress also, in times, it's more difficult than others in certain moments to recollect certain things. In those, sir.
Let me control. So it's easier to recollect an alibi than it is to recollect whether or not the girl that you love told you that she was going to be home alone.
For this question,
That's argumentative as fuck. So yeah, that is objectionable and that is fair. And yeah. fair.
it's argumentative and improper.
Sustained.
Sure. So it's easy to remember where you went on the 19th. Is that
The thing is Cruz is not upset by that being sustained because that question was not really being asked to the witness. That question was being asked to the jury, right? And he's like, jury, isn't it odd? That's what he's doing here. So
correct?
That is correct.
Okay. Mr. Melton, so after you left Nash Plumbing, where did you go?
After I left Nash Plumbing, I went to the bank.
Okay. Can you write the time that you arrived at the bank on the board? You can just put bank and then you put the time. Sure. So just to ask you, so you can remember that you went to Nash Plumbing, and then after that, you can remember that you went to the bank from January 19, 2001.
That's correct.
But you cannot remember from January 18th whether or not Ms. Baker told you she was going to be alone?
At that time, it could depend on when the question's asked. It's not, if it's in a stressful moment, I'm going through things.
low
and
defense
trying to
rests.
pull from times prior to this, when I'm not trying to, how should I say, lock in on certain things previous to this, it is difficult.
Would you agree?
Previous to her death. Go ahead.
I didn't hear you. Say that one more time.
I should say, it's like certain days, if somebody asks you what you had for breakfast, I couldn't tell you. But if I'm concentrating on it after certain times, yes, I can, on certain things. But
Now, I'm going to give a little bit of a spoiler here in terms of things because at the end of this, I don't get to Chris Melton could be convicted on this. What I do get to is I think the defense has done a very good job on, on pushing reasonable doubt. So like, I can't walk away from this saying, yeah, Melton's guilty, right? I can walk away from this saying Melton looks sus as fuck, right? He, and the thing is if this was a game of Among Us, I'd be like, this guy's going out the airlock. And sure, I'm only like 75%, 80% sure that he goes to the airlock, but that's still a pretty good airlocking percentage, right? It's possible he's just very unlucky and just comes off strangely. But the other thing is, if Melton did do the offense, if Melton is guilty, like factually guilty, whatever, like as opposed to legally or whatever, if he is factually, like if he actually did it, this prosecution makes it basically impossible to ever convict Melton unless Melton does something insanely stupid. And what I mean by insanely stupid is Melton gets into his cups. He has like 17 drinks. If he gets super smashed and says to his buddy, yeah, I totally did commit the murder, then he might go to jail. But, assuming he doesn't make a confession, assuming that they don't have some new DNA thing that gets him on something or whatever else, I think the most likely scenario so far is nobody gets convicted. Now, I could be wrong. We could see, the trial could turn around for the prosecution. It could be that Mr. Faust gets convicted. And if Mr. Faust gets convicted, then, he will probably spend the rest of his life in jail. But, yeah, I don't know. I hate that this is sort of how things go, and one of the problems with tunnel vision in these cases is that you can very easily get to a scenario where nobody can ever, even if you solve the crime, you can't solve the crime. So that's kind of the thought on that one.
It's hard to describe.
So I'll switch gears because I do want to talk about a difficult subject with you. You mentioned that you were told that your DNA was in Miss Baker's anus. Is that right?
Yes, there was a point in time. I know.
And we've agreed that time didn't occur during your recorded interview. Is that right?
I can't recall.
That is fair. So let me ask you this, Mr. Melton. You would agree that Miss Baker did not engage in anal sex with you. Is that correct?
That's correct.
You would.
All right, let's take a brief pause. So, when I did my last stream, I was mentioning about how the defense failed to do a 412 application. And tons of you were like, you need to check your facts because they did do a 412. And so I went and looked through the documents, and thank you to As the Gavel Drops. I went and looked through the documents. So here's the thing. They did do a 412. The thing is that the 412 that they did was not with respect to other people or consensual activities between Faust and the deceased, right? The 412 that was filed, so Crazy Cat Queen, I see say, someone remind me what a 412 is again. It's for the rape shield law. So it's basically saying, you have to bring an application in advance in order to make certain arguments about prior consensual activity. The issue is that they did do a 412, but not one for this instance. And so what they did, I can just pull it up here. So give me a second. Here we go. All right. So amended motion to present testimonial evidence pursuant to OCGA, whatever, 412. Okay. Now, what they actually argue here is specifically that they wanted to be able to get in this evidence, not evidence of a prior consensual relationship between Faust and the deceased, but Mr. Faust respectfully requests that the court permit testimony from CM. Who's the CM? I wonder who the CM could possibly be. That the nature of his sexual relationship with Ms. Baker included vaginal and oral sex, but never anal sex. This testimony is of significant evidentiary value to Mr. Faust because CM's DNA was the only identifiable DNA profile in Ms. Baker's anus at the time of her death, accompanied by contusions of Ms. Baker's anus. Yeah, one of the things about lawyering is that sometimes you've got to say sentences you don't like saying. So But yeah, so they did bring a 412 specifically for the purpose of getting into whether or not this dude ever, you know, like attacked from the south, right? I'm just trying to, so the, that was clearly allowed by the court, right? And clearly allowed in the sense because now they're getting into it. But they don't, I couldn't find, I went and looked through a whole lot of documents. I went through a whole lot of documents looking for it. I couldn't find a 412 for anything for Faust and the deceased, which is why they were prevented from that. So yeah. Vez, I saw this, waiting on a confirmation on a diagnosis of ankylosing spondylitis. Finally putting a name on the pain. I am sorry for the pain, but a diagnosis is always, sort of a helpful thing. So yeah. Also, Vez, I am thinking probably we'll do this. I'm probably going to run a simplified cities without number. Cyberpunk shoot 'em up. I think that should be fun. All right, here we go.
Agree that Miss Baker was sexually assaulted anally. Is that correct?
I wouldn't really know if she was sexually assaulted anally. Like, I don't know.
Well, we can't have it both ways, Mr. Melton.
I don't understand that.
Previously stated that Miss Baker, not Miss Baker, I'm sorry, Miss Bigham and Jeremy Howell told you that your DNA was in her anus. Can we agree on that? Is that fair to say?
Maybe I'm mistaken on how I found that information out. Maybe
I'm going to object to lack of personal knowledge. Mr. Cruz is asking this witness about information that was relayed to him as hearsay by other witnesses who had the actual information.
The question is whether he knows these things, right? Did you know and then do you have an explanation for this detail that we're going to hear, right? Yeah.
So I think that's both lack of personal knowledge as well as calling for hearsay.
All right. Any response to the objection, Mr. Cruz?
Sure. Mr. Melton stated that he was aware that his DNA was found in Ms. Baker's anus. He stated that Ms. Bigham and Jeremy Howell were the individuals that told him. And we're fleshing out his knowledge in regards to what he's aware of, Your Honor.
I think as to the form of the question, I'm going to sustain the objection. You may.
I mean, sometimes the way to do this is just, if I represented to you that your semen was found in her anus, which I'm sure is not in dispute here, can you explain how that gets there?
Phrase if you choose to do so.
Yes, ma'am. Thank you. Thank you, Your Honor. But there should be no reason that your DNA should be in Ms. Baker's anus. Would you agree?
I mean, other than if we have had sex and it has transferred from there and, say, drained down to that area. But
that is interesting that you say drain, because did you know it's the exact same thing the state is arguing in this case?
I mean, it makes sense, though.
It's like interesting choice of words interesting choice of words, because I don't think most people would say drainage, right? There's lots of turns of phrase you could use for that concept. But like, yeah.
So your DNA is in her anus because it drained down in her anus. Is that your position?
I would say that would.
Again, Your Honor, lack of personal knowledge, lack of foundation. There's been no foundation laid that Mr. Melton is aware of these things. That would all be through GBI crime lab witnesses who do have personal knowledge and scientific information. And so there's no foundation for these questions, and he's asking for things that are outside of Mr. Melton's personal knowledge. He's asking about things.
I would object to a speaking objection, Your Honor, and just ask the state to state the ground.
Okay, I'm going to overrule that objection. He was just explaining his objection. I'm going to respond.
So the defense did file motions in limine asking for no speaking objections and for these objections to take place outside the presence of both the jury and the witness. Because one of the problems that's happening is that these objections are basically explaining to the witness how to avoid problems with the state case. And keep in mind, this is a witness who is very much implicated, right? This is a witness with some very strong interest in in the results here, because this witness, this witness definitely, he wants a particular outcome. We'll put it that way, right? Because if Mr. Faust is convicted, that ends his problems. Whereas if Mr. Faust is not convicted, maybe not as much, right? So, yeah, I don't know.
In the same way as the last objection, I'm going to sustain the objection as to the form of the question, allow you to rephrase if you choose to do so.
Yes, ma'am. Thank you. Thank you, Your Honor. Would you agree that in order for your DNA to drain into Ms. Baker's anus, you would have to have sex with her? Can we agree on that point?
Agree.
Okay. Did you have sex with Ms. Baker the day of her death?
No, sir.
The last time you saw Ms. Baker, was it 6 days before, 10 days before?
From the beginning, I said I saw her the weekend prior.
From the beginning, you said that?
Yes, sir.
That you've seen her the weekend, and that has always been what you said?
There was a time that I was confused, and it was 20 plus years later. And then I made a statement that I felt like maybe it was 10 days prior, and I was confused at that point because I have always said, from even meeting with the detectives from the beginning, that we were together that weekend. And then time had gone by, and I had even spoke out publicly for the first time.
Mr. Melton, to my question, is that a yes or a no?
Judge, he's in the middle of providing his.
His answer is non-responsive. Come on. Like,
Again, the witness has a right to answer Mr. Cruz's questions in the manner that he believes the answer should be given.
It's non-responsive, Your Honor, and I would ask the state to stop the speaking objections because they are coaching the witness in the middle of his testimony.
Okay, I'm going to over.
that was also, I think, for the benefit of the jury. And that is using the speaking objections against the state in the way that the state has been using them. So it's just like, all right. Now, I mean, I tell, like, when I'm sort of doing witness prep, I talk to witnesses and I say, well, one of the things is that if it's possible to answer a yes or no question with a yes or no, like with a yes or no answer, then, you do so. But in this case, he's like, the state is coaching the witness. He just told the jury, look, he's being coached on the stand. Runkle, I'm not an anatomy expert, but could oral sex cause DNA to enter the digestive system? No. It'll get broken down by the stomach and all of that. It does not survive the process. So
Rule that objection, and I'm going to sustain the state's objection. This witness is allowed to respond to your question, and if he's in the middle of responding, no one can interrupt. You may continue if you choose to do so.
Well, time had gone by, and then I had spoken publicly. At this point, I have stated over and over again that we were together the weekend before. And then there was a point in time that Tara's mother had stated that she was at her house.
I'm going to object to hearsay.
I am going to sustain that objection.
Your Honor,
Yes.
I don't want to send the jury out, but I would like the approach to understand the parameters of which I could.
So now they're just having a little dispute. Oh, and some people wanted the as the gavel drops Discord. So there we go. Now, keep in mind, this is a bit of a problem with elected judges. Is that elected judges tend to have an easier time running on what do you call it, on convictions than they do on acquittals. So every time, and I'm not saying, I don't know that this judge has been awful. Some people have been saying this judge is awful. I don't know that that I necessarily agree, but if you hate a particular judge and you think that they're super pro conviction, keep in mind that you tend to get more of that where there's elected judges. I've seen that there's another lawyer joining Cruz. I haven't. Midway through trial, they're pulling on another lawyer. Oh, that's interesting. That's really interesting to me because this is a little late in the game for that kind of shenanigans. So I guess we'll see.
Your current residence, I won't say your address, but your current residence is the same residence that your parents stayed in 2001. Is that correct?
That's correct.
Okay. And at that time, you stayed in the basement. Is that correct?
At that time, I would have been on the second story.
Forgive me.
Bedroom.
I asked that question wrong. The week before Tara's death, you went to your parents' home. Is that correct?
That's correct.
During that time, you stayed in the basement. Is that right?
No, sir. I think it was in my old bedroom in the second story.
Of course, indulgence, Your Honor.
I've seen a lot of people saying that the 5 million is a motivation. I don't know. I know. I saw that he wasn't excused for sure. All right, let's. This guy's taking the court's indulgence, and he's taking a little while on it.
So, Mr. Melton, this isn't the first time you've been asked that question, is it?
Yeah, but I get
can't quite remember.
copyright hit.
Do you recall on May 5th, 2024, being asked where you resided when you went to your parents' home the week before Miss Baker's death?
I don't recall the question.
So that one more time, you don't recall what now?
I don't recall.
Being asked that question?
Yes, sir.
Okay, do you recall making the statement, so I was working there and driving back and forth. Well, my parents, we had a furnished basement. So then that's where I was. Do you recall making that statement?
I don't recall making the statement, but it seems okay.
Judge, I move to introduce as defense exhibit number 32, Mr. Melton's May 5th, 2024 interview with Miss Elizabeth Bigham. Minute mark is 1442 through 1448. And before I introduce this, you do recall speaking with Miss Bigham, is that correct?
That's correct.
Okay. Your Honor, I would ask to play minute mark 1442 through 1448 into the record.
All right. Any objection from the state?
I don't think any of the foundation for proper admission has been laid.
The state is running a bunch of like shitty bullshit objections, trying to trying to sort of throw. And I mean, sometimes you do this, sometimes it's the strategy. Some people were asking about the new lawyer on the file. I found the new lawyer. Me pull up his page here. So here is here's the new lawyer, Justin Hill, and I mean, his webpage is pretty simple. He kind of looks like a bit of a badass, although his page is configured badly, so it cuts off his picture a little bit. Yeah, I mean, I don't know anything about him, but he does look. He's got a badass look on his webpage. So, oh, new guy's a different guy. People are saying. So, I did see that guy sitting in the back. So, yeah, new guy's a different guy. All right.
However, if this is that interview, the state would stipulate to the foundation for the admissibility.
Can you all confer about whether that's accurate since you're offering to stipulate?
Who's the new guy then?
Okay. I don't have a problem.
All right. You may proceed. And it is, are you?
See the entry of appearance from the, because I see that this was filed February 5th. So this guy came on very recently, Justin Hill. But yeah.
Asking to admit it, Mr. Cruz?
Yes, ma'am.
All right. And just that portion. Mr.
People are saying, but you can show
Yeoman,
pictures.
Are you objecting to what Mr. Cruz has just offered into evidence? That particular disc.
I don't have a transcript pulled up, Judge, but accepting Mr. Cruz's representation that what he's going to play is the answer that he just asked Mr. Melton about that he didn't recall, I don't have any objection.
All right. And it is at that minute mark that the defense has just articulated is admitted.
Thank you, Your
And
Honor.
you said that was what, Mr. Cruz? I'm sorry, 14.
1442
Thank you. Go ahead.
through 1448.
Okay.
Your Honor. I was working there and driving back with my parents. That we had finished basement. So then that's where I was keeping in well, pretty much Jersey.
That was kind of hard to make out. I'm not sure what that was. You're watching the wrong trial if you want to see evidence against Faust.
There and driving back with my parents. That we had finished basement. So then that's where I was keeping in well, pretty much Jersey. Okay, did you hear that? I was driving back and forth. We pretty much had a huge basement. That's where I was. I was keeping, and then I cut the audio off.
I hear that.
So you were staying in the basement. Is that correct?
I would stay in, there's times I stay in both. We had finished basement and had the bedroom upstairs.
Okay.
And the furnished basement was set up as a place to stay, a place to hang out for whoever. And then
Objection,
also had my,
non-responsive.
Overruled.
So,
You may continue with your.
Come
the
on,
finished
like that
basement
was.
would have like a couch, sofa, TV, things in my old bedroom upstairs. Also had a bed and so forth, and I would stay and hang out in one, stay in the other, depending on who was there at the time. If we had visitors or whatnot. So I would stay in the basement if nobody else is using it.
Narrative.
I'm going to overrule the objection. You may continue.
So with that being said, I feel like both are true. I had my old bedroom and they had a furnished basement.
I'd like to show you what's been marked as Defense Exhibit 33 and Defense Exhibit 34.
I mean, I don't know why he was trying to cut him off. Just let him ramble. Yeah, I said I was staying in the, I said I was staying on the second floor, but I was actually also staying in the basement. It's like, which was it though? Like, are you staying? Okay.
Let the record reflect that I'm showing Mr. Melton what has been marked as Defense Exhibit 33 and Defense Exhibit 34. And Mr. Melton, you recognize Defense Exhibit 33 and Defense Exhibit 34 as photographs of your house. Is that correct?
That's correct.
Okay, and I believe Defense Exhibit 33 is the side of your house, and Defense Exhibit 34 is the back side of your house. Is that right?
That's correct.
Your Honor, I would move to, have those photographs been altered in any way?
No.
And that's a fair and accurate depiction of your home. Is that correct?
Correct.
Your Honor, I would move to admit Defense Exhibit 33 and Defense Exhibit 34 into evidence.
No objection.
They are admitted.
Now, Mr. Melton, you would agree there's a reason why you would say that you were staying in the second story of the house, correct?
As far as
There's a backdoor exit on the basement. I believe that's Defense Exhibit 34, if I'm not mistaken. Is that right?
there's a basement exit, yes, sir.
And there's also a side exit from the basement, which was Defense Exhibit 33. Is that correct?
There's one exit. There's a door on the backside that goes into like a dead space that's more for access.
So Defense Exhibit 34, the backside is a door to enter and exit the basement where you don't have to go in the house. Is that right?
The side door would be. The back door is not.
But either way, there's
So you can go in and out unobserved, right?
the exit there's an exit from the basement and an entrance into the basement. Is that right?
That's correct.
Now, you recall your parents talking to law enforcement?
They did.
And they were one of your alibi witnesses. Is that right? Were you aware of that?
I would say yes. They knew I was there.
And you were their only child?
I am.
And by the time law enforcement spoke with him, you had been staying with him for 4 months. Is that correct?
I had started staying with them after this incident. Yes. So, yes,
After Tara's passing?
that's correct.
So if any other witness said you moved home months before, that would be untrue.
That's correct.
Zora, treats. She'll be here.
I want to talk to you about Miss Baker a little bit, okay? We'll switch gears and come back to some of this stuff. Would it be fair to describe Miss Baker as super friendly?
That'd be a fair statement.
You would also describe her as down to earth.
Correct.
She did not have any racial biases.
No, sir.
And
although she was a law student, you would agree that she was not pretentious.
If I was a prosecutor, I'd be objecting here. Because he's trying to do sort of, I was just about to say he was trying to get something in via the back door, which, God, that's terrible in this context. Okay, he's trying to be sneaky because what he's trying to hint is there's no reason she wouldn't have banged Mr. Faust. Right? That's what they're trying to get to. So, okay. That's where they're trying to be right now. So, Zora, do you want treats? I don't know why she's not coming. That's odd.
I mean, no, sir. Not unless it's for little specialty things like her collections of things, but no.
Now, is it fair to describe Miss Baker as a casual dresser, shorts, hiking boots, sweat top type of girl?
Yes, sir.
She was more of a flats over heels kind of girl. Is that fair to say?
Fair to say.
Okay. And she had more of on her day-to-day appearance, she had more of a casual appearance that did not include daily makeup. Is that right?
would say, I mean, light makeup, if any.
I'd like to show you what would be marked as defense exhibit 35.
No Zora. Weird. Zora, you sure? Okay. Zora shouldn't be outside. She should be inside. I kind of feel like now I have to go check and make sure Zora's okay. I will be right back. Because now I'm like, what the heck? Where's the pupper? So we'll just be back very shortly. I have solved the mystery. I don't know if you can hear me right now. I have solved the mystery. Zora, I have figured out where she is. She did not want to come for treats because Mrs. Runkle came home and she is hanging out with Mrs. Runkle. So she's like, yeah, treats are good, but Mrs. Runkle is better. So, all right, here we go.
Your Honor, I'd like to approach the witness to show him defense exhibit 35.
I did give
Do you
Zora some
recognize the photo of
treats.
Miss Baker?
That's Miss Baker. Mister.
And is that how Miss Baker, makeup-wise, hair-wise, is that how she carried herself mostly on a daily basis?
I'd say yes.
And that's the fair, accurate depiction of Miss Baker as you would remember.
I'd say yes, sir.
Okay. Your Honor, I would move to admit defense exhibit 35 into evidence.
Any objection?
No objection, Judge.
It is admitted.
Thank you, Your Honor.
The other thing I need to figure out how to do is how to get the Furbo camera into this, because I can get the Furbo camera on my screen and I can even do this, which causes it to launch some treats. And then you can see Zora. But I can't get it on the I can't get it to work on what do you call it? Can't make it work so far on what you call it. So
Now I'd like to ask you about the times that you visited Miss Baker's home in Deer Park. Is that okay?
Okay.
All right. Is it fair to say that you've probably visited Deer Park more times than you could count?
I mean, she wasn't there a terribly long time, but I would say, yeah. I mean, we've been there many times.
Okay. And during the times that you visit Miss Baker's apartment, you'd see normal foot traffic. Is that fair to say?
That's fair to say.
And that foot traffic was due to a Walmart being on the opposite side of the neighborhood. Is that correct?
I'd say there's a Walmart. Yes, sir. And
Now, the majority of that foot traffic, it was African Americans walking. Is that fair to say?
it's fair to say.
And those African Americans were typically in the late teenage, young adult range. Is that correct?
I would say it would vary, but I would say young teenagers, I would say.
Now, in regards to Ms. Baker's passing, on January 19th, you testified that you went to the scene of Ms. Baker's death.
That's correct.
And while at the crime scene, you were asked to identify Ms. Baker.
That's correct.
Okay, you were shown a single photo of Ms. Baker. Is that right?
That's correct.
And to let the record reflect that I'm showing the state what has been marked as Defense Exhibit 36. Let the record reflect that I'm showing Mr. Melton what has been marked as Defense Exhibit 36.
I need to figure that out.
You recognize that photo?
I believe it's the photo I saw.
This was a photo that you were shown to ask to identify Ms. Baker?
No,
This was not the
I
photo.
don't believe that was the photo.
Can you describe the photo that you were shown to identify Ms. Baker?
I believe that her head was turned slightly. And there was coverage that
Mr. Melton, you're just shown a photograph of Ms. Baker deceased, and you have not shed a tear.
come on now. I think I need a moment, like,
Sure.
put it all together. Okay.
So let's switch gears.
And again, does this play for people? I did not find that to be super convincing, but yeah.
While we're here, you testified on direct examination that you became so upset that you punched the wall in your apartment. Is that correct?
When I unleashed the emotions, yes.
Okay. And when you unleashed the emotions, you became extremely angry. Is that correct?
I was upset. Yes, that would. I was upset at the situation.
And the way you chose to release emotions through violence. Would you agree?
Yeah. He's like, I didn't mean to didn't mean to say that.
Towards that wall.
But you told the jury that the injuries to your hands came from punching the wall. Is that right?
My injuries came from punching the wall.
Okay. And we've already agreed. Well, you testified that the wall was sheetrock. Is that correct?
That's correct.
I'd like to show you what would be marked as Defense Exhibit 37, Defense Exhibit 38, Defense Exhibit 39, and Defense Exhibit 40. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 37 through Defense Exhibit 40. Your Honor, let the record reflect that I'm showing Mr. Melton what has been marked as Defense Exhibit 38 through Defense Exhibit 40.
I have 37 also.
I'm sorry, 37 through,
Go ahead.
through 40. Please forgive me. Is it okay if I approach you, Mr. Melton?
Yes, yes, sir.
please take a moment and take a look at Defense Exhibit 37 through Defense Exhibit 40. Do you recognize Defense Exhibit 37 through Defense Exhibit 40 as the wall that you punched? Is that correct?
I would say yes.
Okay. Is that a fair and accurate depiction of how that wall looked after you punched it?
I'd say from what I could recollect.
Sure. Has that
So pictures shown to, and I'm guessing those were provided to law enforcement to say, this is the wall I punched, and yeah. So
photograph been altered in any way?
I'm not sure. I wouldn't.
But you have no reason to believe that photograph is not altered in any way. Is that correct?
I have no reason to believe.
Your Honor, I would ask to admit Defense Exhibit 37 through Defense Exhibit 40 into evidence.
Any objection?
No objection.
They are admitted.
Thank you, Your Honor. I would ask the publisher of the jury.
Granted.
what did he just whisper there? He just said something to himself. He just said something to himself under his what is it? Under his breath, and I couldn't make it out. Somebody's saying, have I seen any of today's court proceedings? This is today's court proceedings. So yes, I was watching today's court proceedings. Yeah.
Now let's talk about the injuries to your hands, Mr. Melton.
Yes, sir.
I couldn't get that one.
Of course, indulgence.
I see some people saying keep it together, but I don't think
And the
that's...
photographs of your hands have already been admitted through, as Defense Exhibit 29, elected. Your Honor, I just asked to republish the photographs of the hands to the jury.
Granted.
Of course, indulgence, Your Honor. I need one of these photographs. Mr. Melton, I am going to show you one of the photos from Defense Exhibit 29, and we're going to talk about some of these injuries. All right. Can you see your hands on the screen, Mr. Melton?
Yes, sir.
Okay. And you would agree, for the purposes of the record, I am making a fist. Mr. Melton, you would agree that a fist looks like this. Is that correct?
Yes, sir.
Okay. Can you make a fist and show the jury what your fist looks like? Okay. Excellent. I want to talk about this injury here on the side of your thumb. Can you explain how you got that injury from punching drywall?
My hands are from work.
Are they?
I mean, no, I'm just saying my hands from work are naturally have nicks and such on them, but that very well could have occurred. I mean, from punching through a wall, there's also things inside the wall. There's siding on the wall that has, once you go through, there's nails that may have been there, but.
Yeah, but the thing is, you're making a fist, you're doing this, right? Or you're doing that. That's that part of the thumb is gonna be protected, right? So he's like, there's nails.
At that point, I mean, I have little nicks and cuts just from my profession.
Well, Mr. Melton, isn't it fair to say as a plumber you wear gloves?
No, sir.
You never wear gloves?
I wear gloves, but not 100% of the time. No, sir.
I mean, I kind of do believe this part. The number of people who wear like their gloves all the time. And I mean, just when I'm doing plumbing tasks, usually I'm not wearing gloves. You might wear gloves if you think you're going to, if you think you're going to need them. But usually I'd say you don't wear gloves. So I don't know. That one I was kind of like, okay.
I showed you Defense Exhibit 37 through Defense Exhibit 40. There's a pair of gloves hanging on your wall, Mr. Melton.
Hanging on my wall.
But you don't use them.
when you're working with your hands, you work quickly also. And you don't have time to always have gloves on. And at that point in time, I'm not working with raw sewage or anything. This is new materials. So
Yeah, I watched
with
this
that
earlier
being said,
today.
you not worried about
While I was working.
bacteria or anything infecting your hands. You just work through it.
So today, on February 9th, 2026, you remember exactly how you were working on January 19th, 2001.
It's easily to assess because I worked it for so long.
Sure. But you don't remember whether or not Ms. Baker told you she was going to be home alone the day before her death.
You know, in moments under stress, I can't recall everything.
So let me ask you about this injury here. So did this come from the wall or did that come from work?
Is that an injury?
Right here.
I don't know if I...
Or how about this injury here, Mr. Melton? How would you get this injury on the top of your hand going in this direction from punching sheetrock?
That even appears... Oh, yes. Even when you punch through walls, you got to pull your hand back. I'm punching into a wall, pulling my hand back, punching through a wall. And even at work, I have nicks, cuts, and even burns from soldering pipes and hot materials. I can't tell if that's an injury from hitting something or an injury from work. And it may look like, that even looks like it could be even a slight solder. It's hard to say. I mean, it's hard for me to assess that.
But this is the first time in 25 years that you've ever made the statement that these injuries were from work. Would you agree?
I've never been asked the question as far as if they're from...
And just to make sure we're on
that I can recall.
Just to make sure we're on the same page. Your exact statement was to law enforcement is the injuries... Matter of fact, we don't even have to go to law enforcement. Your exact statement in the court before these jurors was that these injuries came from punching the wall in your apartment. Do you recall making that statement?
Was this prior to being shown pictures?
Mr. Melton, do you recall making that statement?
Yes, I had injuries from my hands from hitting the wall. That's what I recall.
But when I asked you about the injuries, you are now saying that they're from plumbing and hitting the wall. Is that right?
Well, when you're pointing out specific things, like I do have from plumbing, you're going to have nicks and cuts or whatnot from that. Just
my question is, during my examination of you, this is your first time saying that these injuries are from plumbing. That's a yes or no question, if you can.
Since you just asked that question, I guess I would have to say yes. And
once the jurors finish looking at the photos, we'll go over some other photos as well. Now, on the day of Tyra's death, you voluntarily went to the Athens-Clarke County Police Department.
That's correct.
And I believe the state asked you a couple of times, did you hire a lawyer or did you refuse to speak to him? When you agree as the boyfriend, if you refuse to speak to him, you would look even more guilty?
Restate the question.
Sure. The state asked you on direct examination multiple times about whether or not you got a lawyer or whether or not you refused to talk to him. Do you recall being asked that question?
Yes.
Okay. When you agree as Ms. Baker's boyfriend, you would look more suspicious if you refused to talk to law enforcement.
If I refused.
Okay.
Yeah,
So what he's doing here is because on direct, they basically said, hey, isn't it true you cooperated fully with law enforcement? And he's like, yes, I did. And so what the defense is saying is, well, okay, but if you hadn't cooperated with law enforcement, wouldn't that have looked super sketch? So the reason why you were being cooperative is because you didn't want to look like the guilty person. This one kind of cuts both ways, though, because the jury might be going, well, Mr. Faust wasn't cooperative. So I don't know. This could bite him in the ass.
Okay.
So we agree on that. Is that right?
Of course. I mean, I'm always want to be cooperative.
Sure. But that was a yes to my question, right?
Yes.
Okay. You would also agree you would look more suspicious if you refuse to give blood. Is that correct?
Correct.
Okay. You would look more suspicious if you refuse to give hair. Is that right?
Correct.
You would look suspicious if you refuse to talk to him. Is that correct?
Correct.
Now, you conducted an interview with Officer Bill Ricketts on the 19th. Do you recall that interview?
I believe so.
And you state you believe so. Are you certain that you remember conducting?
Yes, I remember an interview on the 19th.
And your father was present with you during the interview. Is that correct?
Yes.
Okay. And he sat with you for the entire interview.
Yes.
Okay. And during that interview is when you told law enforcement that you were at your parents' home at 7:15 on January 19th. Is that correct?
Yes.
And sorry,
Do
I
you
don't know
recall
why,
during the
but
interview being asked
StreamYard is
how would you
sucking right
describe you
now.
and Miss Baker's relationship?
Yes.
And your response was that she was your borderline fiance.
I recollect.
Okay. And you advised him that you and Miss Baker were very serious at the time of her death.
Yes.
I just saw in the chat. I can't pull it up because StreamYard is being crappy, but really, really a cat man saying, dude, most walls where I am tend to be brick or concrete. I ain't punching that. This is a big difference between like Europe and North America, because North America walls are typically wood studs with sheetrock, and you could punch a hole right through them. Whereas, like, you go to London and people's walls are like solid concrete. And so the whole thing of punching a wall is like, well, that's a good way to send yourself to the hospital. And yeah.
I believe you established with the state that the truck you used for work at the time of Miss Baker's death was your own work truck, the truck you purchased. Is that right?
Correct.
Now let's talk about Josh McCourty. The state asked you about your relationship with Josh, and you stated that he was just a coworker that you met at McCart Plumbing. Is that correct?
Correct.
Okay. Josh stays less than a mile away from your home. Is that correct?
Correct.
Josh knew where you lived. Is that right?
Yes, he worked for me.
Okay. You knew where he lived.
Once we became coworkers.
And you two attended the same high school.
That I'm unsure of.
You're unsure if you attended the same high school with someone you stated was your employee, Mr. Melton?
That's correct.
But to law enforcement, you only identified Josh McCourty as somebody that you work with. Is that right?
Correct.
Now, you stated on direct examination that while at Nash Plumbing, you loaded up supplies. Is that fair to say?
Correct.
Okay. But at no time did you provide law enforcement with any documents related to your employment at Nash Plumbing. Is that right?
That's correct.
So in regards to your alibi that you were at Nash Plumbing at 7:30 through 7:45, we just have to take your word for it. Is that correct?
I would say so at that point.
And law enforcement did, in fact, just take your word for it. Is that right?
I'm not sure. I would say to my knowledge.
Sure. Now, you stated after leaving, today you stated after leaving Nash Plumbing, you went to the bank.
Correct.
And did you go over that with the state when you all met?
I knew when I had gone to the bank, but yes.
Okay. And you all discussed your timeline before you came to testify here today?
I had gone over it, a refresher.
However, on January 19, 2001, you told law enforcement after leaving Nash Plumbing you went to Truck Customs. Is that right?
I'm sorry, I may have not heard you all the way. Say it again.
Sure. On January 19th, 2001, when law enforcement asked you what were you doing that day, you told law enforcement that after leaving Nash Plumbing, you went to Truck Customs.
On the 19th. Yes, I did say that.
And you advised law enforcement that you arrived at Truck Customs around 9:30 or maybe earlier. Is that right?
Not earlier. Probably 9:30ish. 10.
Mr. Melton, this isn't the first time that you've had the opportunity to discuss your whereabouts on January 19, 2001. Is that correct?
I have been questioned in the past.
Okay.
Several times.
And you told do you recall making the statement, Truck Customs spelled with the K, TRUK, KUSTON, and you were asked, okay, and do you know about what time it was? You made the statement the first time was about early 9:30, maybe earlier. Do you recall making that statement?
That seems fair.
So at some point you leave Truck Customs, is that correct?
That's correct.
And I'm sorry, Mr. Melton, do you still have that marker I gave you? right, perfect. Can you write truck customs on that under the bank? And the time
I thought he was going to say, "Can I have that back? I need that."
that you were at truck customs? All right, and you can say right there, Mr. Melton, if you're comfortable. You can write the time next to truck customs. Okay, so now it's not 9:30, it is 10 o'clock. Okay, let's do 9:30 through 10, just to make sure that's accurate for the jury.
And Judge, I would ask that if there are going to be questions asked, that the witness be allowed to return to the witness stand so he can speak into the microphone.
I think that makes sense. Everyone can hear, including Ms. Satterfield. So you may have a seat and answer any questions in front of the microphone. Go ahead.
So at some point you would agree that you leave truck customs, is that fair?
That's correct.
Okay, and when you leave truck customs, you go to Grayson, Georgia, correct?
Correct. I go to Grayson.
Now, and you can write Grayson on the board for us, please. All right. So, do you recall speaking with Detective Ricketts 2 days later on January 21st, 2001?
Not yet.
Yes.
No.
And would you have any reason to disagree that January 21st, 2001 was a Sunday?
No.
During your second interview, you advised Detective Ricketts that you stopped by the bank. Is that correct?
Yes. Then I had failed to mention that I went by the bank that morning. Yes.
And you stated that you were in the bank for a total.
They also bring they bring a bank employee in. So
of 35 minutes. Is that right?
Sounds about right.
Okay. Next to bank, can you put 35 MIN and circle it? Just you put it there. That's fine. Now, during your second interview, do you recall Detective Ricketts coming to you and telling you that he went to speak with someone at Truck Customs?
Yes.
Okay. And in response, before he could tell you what he learned, you would agree that you changed your answer about the time that you went to Truck Customs. Is that correct?
I'm not sure. Not.
Do you recall making a statement? It's like before 12. I mean, it was probably 10:30, 11:30. Do you recall making a statement?
I don't recall the statements, but yeah, I would say. I mean, I would say okay. Yeah. Yes.
Yes or no, Mr. Melton? Do you recall making a statement?
I'll say yes. Yeah. Yes.
So is it fair to say that the actual time is between 10 a.m. and 11:30 on the 19th? Based on your statement?
As far as being at Truck Customs,
Yes, sir.
and you stated what you did say. What did you just say? I'm sorry.
Would it be fair to say that the actual time of being at Truck Customs is sometimes between 10 a.m. and 11:30 a.m.?
That's pretty broad, but yeah, I would say okay, it would fit in there.
Now, during the January 21st, 2001 interview, you were told for the first time that Ms. Baker was sexually assaulted. Is that fair?
Can you repeat the question?
Sure. During the January 21st, 2001 interview, you were told that Tara was probably sexually assaulted.
this is
I don't
this is
recall
a
being
bad
told at that
fact
point. I had
for defense.
been told. Adam, Tara's brother, had called me that morning and had kind of informed me that this is what we're looking at, that they had been informed.
So let me ask the question again. On January 21st, 2001, you knew that Tara had been sexually assaulted. Is that right?
At that day, yes, I had been informed that day.
Now, law enforcement also informed you of that. Do you recall?
I don't recall.
Would hearing the recording refresh your recollection?
I would say if I heard it, it would help reflect. Yes.
Your Honor, I'd ask to refresh this witness's recollection outside the presence of the jury.
Right, and this is a good time for a restroom break, so I'm going to send you all into the jury room. This will be a good restroom break, so we'll take a little bit of time. Please don't discuss the case.
It's like everybody goes to pee. Okay. So we're going to skip ahead. And it's actually a fairly long skip. Here we go.
Go back on the record. Mr. Cruz, are you ready for the jury to come in? Okay. Oh, that's right. Of course. All right. Are you ready to begin that? All right. Very good, sir. Go ahead.
All right, just for purposes of the record, let the record reflect that the last question asked to Mr. Melton was during the January 21, 2001 interview. And stated as said it, you were told that Tara was probably sexually assaulted. At this time, we were refreshing his recollection. We were playing Chris Melton's January 21st, 2001 recorded interview. Minute mark 11:51 to 12:02 for purposes of refreshing Mr. Melton's recollection.
Oh, it reverted to Bill? It's on lawyer right. Oh, thank you.
I just don't know, like, you listen to this and let me know if your memory is
We
fresh.
can barely hear anything on it, so
Bombers and that kind of blood people there. They take it, store it, put it in evidence, and then on Monday morning, we've got a good working relationship. They'll start right away for us and tell us exactly what we've got.
sadly we can't hear much of anything here, but that's just the way life is.
Did their thing Saturday, and of course on the weekend there's none of the bombers and that kind of blood people there. They take it, store it, put it in evidence, and then on Monday morning, we've got a good working relationship. They'll start right away for us and tell us exactly what we've got. Tara was probably sexually assaulted.
Yes, sir.
All right, could you bring the jury in, please, sir? Thank you.
So all of that happens outside the presence of the jury because the jury can't necessarily hear that recording. So
You all may be seated. Mr. Cruz, you have the floor.
Thank you, Your Honor. And Mr. Melton, during the January 21st, 2001 interview, you were told that Tara was probably sexually assaulted. Is that correct?
Correct.
All right. You would agree that you didn't start a crime. Is that correct?
Correct.
You didn't become upset. Is that correct?
I would say not correct.
You said that's incorrect.
Incorrect.
Did you make outward expressions of anger?
No.
You didn't say you needed a moment to yourself, right?
Correct.
You didn't even say, I hope you find who did this before I do, did you?
Correct.
Instead, you asked calmly, did you find some stuff on her like semen? Is that right?
Correct.
I mean, he might be asking, why do you think she was sexually assaulted? But it sounds, and it's going to sound to a jury, like why he's asking is, well, I really hope you didn't find anything that points to me, right? And it doesn't sound great. So
Now, at the conclusion of the January 21st, 2001 interview, and I believe you've seen the photographs of your hands, pictures were taken of your hands. Is that right?
Correct.
And I think I have a better version of those hand photos I would like to show you. This is going to be marked as Defense Exhibit 41. There are 13 photos in Defense Exhibit 31. It will be a omnibus exhibit, photos of, or better quality photos of Mr. Melton's hands. While the state is reviewing the same, Your Honor, I'd just like to clarify the record. With Defense Exhibit 29, there are there are 9 photos in Defense Exhibit 29.
Sorry, say that again?
Just for purposes of clarifying the record, for Defense Exhibit 29, there are 9 photos collected in Defense Exhibit 29. Let the record reflect that I'm showing Mr. Melton the 13 photos of his hands marked as
this
Defense
is trial
Exhibit
from
41.
today. See, at this point, his cross-examination is slowing down a little bit. It's like, you need to be keeping this guy on the ropes. You need to not get bogged down in this shit. Ooh.
You would agree that Defense Exhibit 41 is. You would agree that Defense Exhibit 41 is the same thing you saw in Defense Exhibit 29. I want to change that. Please forgive me. You'd agree that Defense Exhibit 41 are photographs of your hands. Is that correct?
Correct.
Okay, and a little bit better quality than Defense Exhibit 29. Would you agree?
I would agree.
Okay. And those photos are a fair, accurate depiction of your hands as they were on January 21st, 2001. Is that right?
Correct.
Okay, Your Honor, I would move to introduce Defense Exhibit 41 and the 13 photos included in saying into evidence.
Any objection?
No objection, Judge.
They are admitted.
Okay, thank you, Your Honor. Now, after the photographs were taken of your hands, while at the hospital, you did a blood draw as well. Is that correct?
Correct.
And you remember giving a blood draw. Is that right?
Correct.
Okay, and that's January 21st, 2001.
Correct.
Okay. After you were asked for hair and blood in January, your parents told you they're going after you, Chris. Do you recall them making that statement to you?
Yes.
You know,
That is also kind of a hearsay thing because it's like, do you recall them making that statement? Yeah, but why is he asking? He's asking specifically so that the jury will think this guy did it. I mean, there's no objection, but I was like, okay, pushing it.
you discussed with the state the photograph you were shown of Miss Baker to identify her body. Do you recall us talking about that?
Earlier,
Hmm?
when you showed me,
Correct.
unfortunately, yes.
Okay. And you said that that was not the photo that was shown to you to identify her body. Is that right?
I don't believe so.
Okay.
I,
Go ahead, Mr. Melton.
I was looking through a digital camera with a small frame, and it was fuzzy, and it's hard to. Anyway, it's not as high quality as what you're showing here, but no.
But we can agree she had a sheet over her body. Is that right?
I believe she had something draped across her. It was at the bottom frame of the digital image.
All right. So I asked you this question: do you remember telling law enforcement that the photo shown of you, Miss Baker, had a blanket covering her from the neck down? So I saw her face and her hair.
Correct.
And the photo I showed you was a photo of Miss Baker with a sheet covering her from the face down, the neck down, and you saw her face and her hair. Is that right?
Correct.
Okay,
Correct.
But we can agree you did not see a black cord wrapped around Miss Baker's neck. Is that fair to say?
That's fair to say.
Pasha, you probably could become a judge in 25 years.
Mrs. Virginia Baker.
Could have been a judge by now, yeah.
Wrapped around Miss Baker's neck.
Not a black cord wrapped around her neck, no. I don't recall that.
You don't recall?
I do recall in the original photo that I saw, there was something draped over her, and I could recall seeing something black. I didn't know what it was. But like I say, I don't think that's even the image I saw.
So, Mr. Melton,
They wouldn't have shown him a picture that still had the cord wrapped. Like, I mean, this guy is weaseling here, and it's not great.
speaking, the specific question I'm asking you, and you might have answered, I just want to make sure I'm clear. In the photograph you saw of Miss Baker, it was her with a sheet from the neck down. Do we agree on that?
The one you showed me, yes.
Okay, not the one I showed you, the one you described to law enforcement.
I believe I stated there was something from, I don't know if I said sheet, but in the digital camera at the bottom section of the frame, it kind of stopped. You could kind of see something laying there.
Sure, Your Honor. Mark, I moved to Mark. Mark, the audio recording of Chris Melton with Detective Newton as defense exhibit 42.
That's certainly what the defense is suggesting, that this guy is having knowledge of a black cord that, and it's like, how do you know there was a black cord? Well, I don't know. That's where the defense is trying to go with that.
Page before I play this. Law enforcement asked you, do you remember how much of her was exposed during that, in that picture that you saw? Your response was, they had a blanket covering from the neck down. So I saw her face and her hair, you know. You were asked, okay, you couldn't see any of her body or body parts. Your response was, no, I did not see any of her body. You don't recall making that statement?
I recall.
Now, you testified on direct that this was just a terrible experience for you. It destroyed you. Is that fair to say?
Yes, sir.
And you and I both could agree Ms. Baker's death is a true tragedy.
Yes, sir.
Okay. On Thursday, January 25th, 2001, you went to Miss Ashley Peavy's house. Is that correct?
What's the dates?
January 25th, 2001.
Yes, sir.
Okay. And this is 6 days after Miss Baker's death.
Okay. Yes, sir.
Okay. And while at Miss Peavy's home on the 25th, which we've agreed is 6 days after Miss Baker's death, you called Miss Leah Tucker. Is that right?
Yes, sir.
Okay. And it was after 8:15 p.m. It was nighttime. Is that fair to say?
I can recall the time.
That's fair. But you set up a dinner with Miss Tucker at 5:30 p.m. the next day. Do you recall that?
I don't recall that, but it sounds she was a close past friend. Yes.
All right. And then on
So the argument here is, and you didn't even really wait for the body to cool off before you were, shopping around, I guess would be the way to put it. So, I don't think that'll play well for a jury.
January 26th, despite your future fiance being brutally murdered, you called Holly Hufford. Would you agree with that?
I don't remember Holly Hufford, but I do recall someone that was hurting, like as in anguish, but I don't recall who Holly Hufford is.
You remember somebody else hurting and being in anguish?
Everybody around us.
But you set up a lunch with Holly Hufford for Friday the 26th.
I don't recall.
Okay. But we can agree it wasn't Miss Holly Hufford's fiance that died. It was your fiance, right?
That's correct.
Do you recall Miss Ashley P.B. Hall joining you and Miss Hufford for lunch?
I remember us joining for lunch with someone. If this is Holly, okay, yes.
Okay. And during that lunch, you were flirting with Miss Hufford 7 days after your fiance had been brutally murdered.
Reflected? Is that what you asked?
Flirting.
No,
You did not?
no.
During that lunch, you were gently rubbing Miss Hufford's lower back.
No, I recall this individual having an emotional moment, describing what she was going through.
You see him turn. You see him turn towards the jury.
Having an emotional moment, describing what she was going through. And I realized this person was
It's like, oh, now you're doing the Amber. Now he's doing the Amber Heard.
in pain. And I reached over and I believe I did like a comforting touch to just acknowledge that it's okay. They're not okay, but to have her understand that we're all going through this and it's going to be okay.
Would you be surprised if Miss Hufford said that she was shocked by your actions during the lunch?
I would be surprised.
After lunch, Miss Ashley P.B. Hall and Chris Hall, they left. Do you recall that?
I say vaguely. Okay.
Do you recall telling them that you were going to continue hanging out with Holly?
This is a long time ago. I don't really recall this, but it would sound like someone who was, yes, that I would try to comfort, not flirt with or try to set up a date or anything. No.
Well, let me ask you this. On January 27, 2001, isn't it true you tried to comfort Miss Hufford at 10 p.m. At 10 p.m.?
How so?
Did you contact Miss Hufford after 10 p.m. on January 27, 2001?
I could believe I could have made a phone call.
Do you think it's appropriate to call women at past 10 p.m. at night after you just lost your fiancé?
I'm going to object to the form of the question argumentative.
Sustained.
Yes, ma'am. Didn't you invite Miss Holly Hufford out on the town when you called her past 10 p.m. that night?
Honestly, I don't recall the conversation.
Now, again, we discussed.
The thing is that everybody copes differently with loss, but this does not feel great, right? This feels like a little bit of shopping around.
How much are you told this jury how much Miss Baker meant to you, correct?
That's correct.
Okay. Do you recall discussing with law enforcement Miss Baker's law school memorial service that was held shortly after her death?
Yes.
And that discussion occurred on June 20th, 2001.
Okay. I'm not sure about the time.
Do you have any reason to disagree that it occurred on June 20th?
No.
Instead of attending Miss Baker's law school memorial service, you went to a country concert, correct?
Correct.
And you knew about the memorial service 4 days before the concert, is that correct?
Correct.
And your stated reason for not going to your fiance's candlelight vigil was because another woman talked you into going into a concert with her. Is that correct?
correct? Can I give further explanation?
Well, I have a question for you. That woman
The further explanation should be something that gets dealt with on redirect, not, so.
was Lauren Sherling. Is
I think the witness is asking for some direct.
Right. Well, and I think the record needs to reflect the witness was asking the court a question, which is not necessarily appropriate, but based on the state's interjection, I will say this with regard to all witnesses. All witnesses must answer the question if they can, yes or no, and they are entitled to explain. And so I'll let you ask the question again. And if this witness has the opportunity to explain, feels he needs to, he is allowed to by law. But you may ask the question again, Mr. Cruz.
yes, ma'am. He answered my question.
Yeah.
So the question I do have for you is that woman was Lauren.
And this is basically what his answer is going to be, is like everybody is super, super judgy, right? He shows up at things and people are like, huh. And I mean, it's not, people can do the math, right? Normally it's, I guess most commonly, if you've got, there's a woman who died, people look to the boyfriend, right? That is, yeah. So,
Object, Your Honor. I think that the witness is allowed to explain his answer.
And I would ask you to go back to the former question, Mr. Cruz, and we'll go from there.
Yes, ma'am.
All right, go ahead, sir.
The question that I asked you, Mr. Melton, your reason for not going to the candlelight vigil was because another woman talked you into going to the concert.
No, that's not accurate.
That woman was Lauren Sherling.
That is accurate.
Okay.
wait, it's not accurate that another woman talked him into going to a concert, but it is accurate that her name was like, okay.
Can I explain? Do I have the opportunity to do I?
All witnesses are allowed to answer yes or no and explain their answer if they choose to do so.
Okay, well, I choose to explain. Lauren was one of Tara's closest friends that loved Tara. She worked with her at the law firm in Athens. That's how they met. They became very close. Along the way, we all became close. We were all extremely grieving. There was a time that we did not see each other as far as physically in proximity, but she would reach out periodically and check in to see how I was doing. She was a very dear friend. She is one of the only few that actually would reach out to see how I was feeling, and then we would converse and we would talk about our feelings of the situation. At the time of this vigil, I did not know anybody at the law firm. I was grieving. I also was feeling extraordinarily uncomfortable with any presence I was of anybody that knew the situation. I would walk in to any room or any environment, and then people would separate, create distance, look at me with angry eyes. So I did not feel comfortable being there. As much as I wanted to show respect, as much as respect as I had.
Overruled.
So with that being said, Lauren had an opportunity when she called me up.
He's like, people were judging me. I get it. I mean, this is not super crazy to me as a thing, although his demeanor on it is making me go, but I mean, who knows, right?
Had an opportunity to create in a different environment for myself. She said, maybe you need a different headspace, come out and try to enjoy something. And so she invited me along with her group of friends, and she had these tickets for an extended period of time. And she had one, and she says, if you want to join us and try to get a different headspace, maybe this environment will make you feel better. And so I accepted, and genuinely, it did make me feel better.
Okay. So to my question in regards to your reason for not going to the candlelight vigil was because another woman talked you into going into a concert with her. Your answer was no. Is that right?
You stated that she talked me into going. She didn't. She heard me through, and I believe that it's more of she gave me permission to accept that it's okay, Chris. It's okay that you can try to do something to feel better about your situation.
Let me ask you this, Mr. Melton. I think you and I could agree you're a very charismatic person. Have you heard that before?
Yes.
Okay. Is this the way you were talking with law enforcement when they were interviewing you?
I wasn't aware if I was. I mean, this is my demeanor.
Sure. When the state and yourself was going over your testimony, is this how you were talking with the state as well?
I'm unaware. I mean, this is who I am.
But I would like you to answer my question with a yes or a no. Okay.
I'll try my best.
The reason you didn't go to the candlelight visual is because Miss Sherling told you you shouldn't go. Is that a better way to put it?
No.
Mr. Melton, this is your first time discussing the candlelight visual, is it?
It's been discussed with a detective.
Okay. And your statement was, or do you recall making a statement, and which even Lauren didn't go to that when she was part of that. Even the people she worked with were going to be speaking there at the memorial service. And they suggested to her that she shouldn't come. And I talked to her about it. And she's like, it's not something you want to be at, Chris. It's just not trying to talk me out of it, just trying to tell me how the situation is going to be. But I didn't go to that. Is that accurate?
If that's on a recording and you have it verbatim, that I don't.
My question is that accurate? Yes or no?
I don't think it's completely accurate.
I move to introduce defense exhibit.
It's not a great answer to that.
The June 20th, 2001 audio recording between Mr. Melton and law enforcement. Now I ask them to report to introduce time stamp. .425 to 455, Your Honor.
Do you have a number of that exhibit?
Defense exhibit 43.
43. And I'm sorry, say it one more time, the time stamp.
4 minutes and 25 seconds to 4 minutes and 55 seconds.
All right, thank you. And you're asking to introduce that?
Just that portion, correct.
All right. Any objection, Mr. Yelman-Shilly?
There's been no foundation laid for the recording, Judge. So that is our objection based on foundation.
All right, I'll sustain that objection. Allow you to lay a foundation, Mr.
Sure. Excuse me. You recall talking to law enforcement in regards to going to a country concert with Lauren Sherling. Is that correct?
Correct.
Okay. And you hadn't heard this audio recording. Would you like to hear this audio recording?
In the section that you're referring to, I would say yes.
Okay, perfect. So, Your Honor, this is what I would ask. I would ask if I could allow the witness outside the presence of the jury to listen to that portion of the recording to determine if he recognizes that recording, Your Honor.
All right, any objection, Mr. Yelman-Shilly?
No, Judge.
All right, ladies and gentlemen, I'll have you leave for a moment. Don't discuss the case. This is another break, and we will take a lunch break. Don't worry. We'll be back with you shortly. Thank you.
All right, we're gonna jump ahead because the place where I've got the stream from plays ads during their breaks, so that we're not gonna do.
Days probably before the concert, in which even Lauren didn't go to that when she was part of that. Even the people she worked with were going to be speaking there at the memorial service, and they suggested to her that she shouldn't come. And I talked to her about it. And she's like, "It's not something you want to be at, Chris. It's just going to not trying to talk me out of it, just trying to tell me how the situation's going to be." But I didn't go to that, and we discussed. I even talked to Lauren about it the night before, just discussed if I should go to that instead of the concert, and saying, "Hey, I feel I should be there too." And she's like, "Well," she told me what the people at the law firm told her what it's going to be.
Yes, sir. Yes, sir. Yes, sir.
Ready for the jury? All right, could you bring the jury in, please? You all may be seated. Thank you.
Yes, ma'am. Thank you. You'd agree that you and Ms. Sherling agreed to go to the country concert over going to Ms. Baker's candlelight visual. Is that correct?
Correct.
Now, at this concert that you went with Miss Sherling, to, there was a total of 6 people. Is that correct?
Sounds accurate.
Okay. It was Miss Sherling's mother and father. Is that right?
Yes, sir.
Okay. It was her neighbors, which was a guy and a girl couple.
Yes, sir.
Okay. And this was a country concert at Turner Field.
Correct.
Okay. So you and Miss Sherling left Athens when Miss Baker is having a candlelight visual to travel to Atlanta to go to a country concert.
I don't remember where we left from. I don't recall that. But I do recall going to a concert, and it was in an open stadium, and you get to walk around and listen to country music.
You remember that, but you don't remember whether Miss Baker told you she was going to be alone the day before she died.
Sustained.
I mean, I'm naturally biased
Chris,
against
the
him
week
for
before
listening to
Tara
country
died,
music,
there was an
but
incident between you and her that jeopardized your relationship with her. Do you remember that?
I remember being asked about the question.
Do you remember the incident?
I remember nothing happening the week before, but I had answered a question to a detective, and I remember telling there was an incident that always stayed in the forefront of my mind that I realized I had hurt her feelings, but I didn't realize at that time the question was.
I thought this one was probably. So I'll tell you what the incident is. The incident is not, to my mind, super. So the incident is she found a porno movie, like on VHS. Like this guy had a very classic kind of porn, and I'm like, I don't know if this is actually going to. I don't know if this is going to go very far, because all right, it. I don't know. This feels a little odd, but here we go.
The week before, because the incident that I explained happened months before.
All right, so your testimony today, Mr. Melton, is the incident that occurred before Miss Baker died was actually an incident that occurred months before Miss Baker died.
Where he had asked, he goes, has there ever been a time that you felt that something you had done jeopardized your relationship? I think that's close to accurate, but my answer that I gave was off the forefront of my mind that had always stayed there, but it did not happen the week before. I haven't stated that in questioning, but it was not the week before.
I just want to make sure we're clear on the question that I asked, okay? The week before Miss Baker's death, there was an incident between you and her that jeopardized you two's relationship.
No, sir.
This isn't the first time you've been asked that question, is it?
No, sir.
On June 20th, 2001, law enforcement asked you that question. Is that correct?
That's correct.
And your statement to law enforcement was, yes, I remember that incident. Is that correct?
No, I remember I started telling about an incident.
Your Honor, I would ask to play minute mark 621 through 650 of Defense Exhibit 43.
Any objection, Mr. Yelvin?
43 in evidence?
Correct. Well, we did the timestamp is,
That one time, well,
and forgive me if I didn't move
it's
to
not
it.
in evidence.
Please forgive me.
It is not in evidence. So is there an objection to, and we can talk about that later. Let's talk about the request that Mr. Cruz has just made. Do you have an objection to what he has just requested?
Just a foundation, Your
Okay,
Honor.
I will sustain that objection and allow you to lay a foundation. Mr.
Okay. And you've already stated that you remember talking to law enforcement about that. Is that right?
I do.
Okay. And
So he's stumbling through objections.
you
He's
two
stumbling
specifically
through
discussed the incident between
getting
you and
some of
Tara
the
the week
stuff.
before she died. Is that right?
He asked the question, but I'm not hearing it correctly at the time. It was an incident that had happened in the past, but not the week before. But he does ask that question.
So let me do it this way. Did you admit to law enforcement that an incident occurred with you and Miss Baker the week before her death?
I would have to say yes, but it wasn't accurate.
Well, we can't have it both ways. First, you said it was months ago.
I'm going to object about editorializing about the witness's answers.
I'm going to sustain that objection.
Sure.
Mr. Cruz, you stick to your question.
Yes, ma'am. Your original answer was that this incident was months ago. Is that right?
Yes.
Okay. But your answer now is you do remember the incident the week before she passed away.
I remember the question he asked, but the explanation and what I had described did not happen the week before.
But you told law enforcement it happened the week before.
He asked the question, and I gave an answer, but it was not the week before.
Well, Oh, go ahead. I didn't mean to cut you off.
I didn't mean to cut you off.
No, you're fine. My specific question is, did you tell law enforcement that the incident happened the week before her death?
He asked that question, and I did not say that it happened the week before. I went into an explanation of what, in my forefront of my mind, had at some point jeopardized our relationship.
Your Honor, I would renew my request to introduce minute marks 621 through 650 into evidence as a prior and consistent statement.
Mr. Yamamoto.
Well, there were a lot of questions. None of them had to do with the foundation for the exhibit, however, which was my objection.
I think that's correct. So I'll sustain the objection, allow you to lay a foundation, Mr. Cruz.
You haven't heard what's on this flash drive, have you?
The flash drive?
Right. You haven't heard what's on this flash drive, correct?
I don't know what's on your flash drive.
Let me ask you this. Did the state play your interviews for you?
I have heard the interviews.
They played them for you?
I have heard the interviews.
Okay. So you're familiar with your interviews with law enforcement, is that correct?
That's correct.
Okay. And you are familiar with the interview that took place where you discussed with law enforcement the incident that took place the week before her death, is that right?
Yes, I'm familiar with that question.
Okay. And the reason you're familiar with it is because you've heard the interview, correct?
Well, I'm familiar with the question from originally, plus after 25 years, I think it's fair to say that I need to hear what I've said on recording.
So you'd like to hear it to determine if it's a fair and accurate rendition of your statements to law enforcement on June 20th, 2001?
I'd like to hear to see if it's accurate.
Why are they? Why is Law and Crime rolling a baked-in ad? That's not, because that's a baked-in ad.
Minute mark 613 through minute mark
Or not
649.
Law and Crime. Who's this? This isn't Law and Crime. This is some station rolling a baked-in ad for a spice cake right in the middle of it. I'm like, why?
The foundation for this audio.
Anybody now, even if another thing was issue, we'll call it issue until we hear from you, was brought up to us, something to the effect that like a week prior to Tara's death, Tara had found out some information and could have maybe jeopardized y'all's relationship. Do you remember having a discussion? I think something that you might have found at your apartment now. I think she went there to leave you a note or something. Yeah, I know it was. Okay. How about?
Did you have an opportunity to hear that, Mr. Melton?
Yes, it did.
Okay. Is that you on the audio recording?
Yes, it is.
Okay. Is the minute 6 minutes and 13 seconds to 6 minutes and 49 seconds? Is that an accurate? Is that an accurate portion of your conversation with law enforcement?
Yes.
Okay, you recognize this audio recording. That's the conversation you had with law enforcement on June 20th, 2001. Is that fair?
Yes.
Okay. Does it sound like it's been altered in any way?
No.
Your Honor, I believe the proper foundation has been laid for the audio recording. I'd ask that the jury be allowed to come back in.
All right. Thank you. Mr. Yamamoto, do you have an objection?
I think at this point, the foundation has been laid. However, I did not hear a prior inconsistent statement. It's exactly what Mr. Melton said, which is that he got asked the question and then he launched into an explanation of what happened without correcting the date. So there may be something beyond this that Mr. Cruz wants to play that shows the inconsistency, but I believe, as far as what I heard, Judge, it was exactly what Mr. Melton testified to, which is that, yes, in response to that question about a date certain, I started to launch into an explanation about the only incident that I could think of, but it is not actually from that date. I didn't clarify that for law enforcement, which seems to be what happens on the recording, but obviously the court heard the recording as well and can draw its own conclusions.
Mr. Cruz, any response
That's-
to Mr. Yamamoto's comments?
Absolutely, that's a misrepresentation. Law enforcement clearly asked him if he was aware of an incident that occurred the week before Tara's death, and Mr. Melton, before I cut the recording off, said, yes, I'm aware of that incident. My specific question to him was, Mr. Melton, was there an incident? Well, my specific question to Mr. Melton was, Chris, the week before Tara died, there was an incident that upset her and jeopardized your relationship with her. Do you remember that? His first answer was no. It was months ago that it happened. I just And eventually we got to him saying, well, I just told law enforcement that it was. That is I confronted him with the statement, Your Honor, I would ask that I'm allowed to impeach Mr. Melton with a prior inconsistent statement, because Mr. Melton danced around the answer. He wouldn't give me a clean yes or no.
I'm going to ask you to play it again because I did not hear what you're articulating.
Yes,
So I'd
ma'am.
like to hear it again, please.
Yes, ma'am.
Thank you.
Another thing was issue, kind of with all the issues until we hear from you, was brought up to us. Something to the effect that like a week prior to Tara's death, Tara had found out some information that upset her and could have maybe jeopardized y'all's relationship. Do you remember having a discussion?
All right, thank you. That's what I thought I heard. So I think that we are at a moment of the interpretation of semantics.
Sure.
But I do think semantics matter
Yes,
in this
ma'am.
moment. And what the officer just said, which is why I needed you to repeat it, was that something happened the week before where Ms. Baker had learned of something. And that is a different set of words and a different phrase than what you're asking Mr. Melton. And so based on that recording and based on the questions that you are asking Mr. Melton, that's not a prior inconsistent statement. You certainly may continue questioning him, but that does not qualify as a prior inconsistent statement. If there's more context, for example, in that recording
Sure.
that supports the way that you have asked the question, we certainly can get into that. But this particular thread that you have played very specifically says when she learned of something, and that is different than what you've asked.
Yes, ma'am. That's fair. We could bring the jury out. I've played it. He's laid the foundation for the recording. I'll ask the appropriate question, and depending on his response, we'll take the next steps.
All right. You may bring the jury out. Thank you. Y'all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Thank you, Your Honor. Mr. Melton, do you recall
So the issue is that you can play a prior inconsistent statement for the purpose of cross-examination, but if his statement is consistent, then you can't, and you can't actually play that even to help the witness. It's just at that point it's hearsay. You've just got it through the witness who's sitting in court.
person asking you that like a week prior to Tara's death, Tara had found out some information that upset her and could have maybe jeopardized your relationship. Do you remember having that discussion? Is that
Yes,
accurate?
they asked that question.
Sir?
Yes.
And you were told, I think she went there to leave you a note or something. Do you recall that?
I recall them saying yes.
Okay. And your response was, yeah, I know what it was.
Yes.
You'd agree that you never disclosed that information to law enforcement until you were asked about it 5 months after her death. Is that correct?
That's correct.
You never shared with law enforcement the issue that led to Miss Baker not spending Christmas of 2000 with you, did you? Or Christmas Eve. Let me use the right day. Christmas Eve of 2000 with you. Is that correct?
I believe we're together Christmas Eve.
Your testimony here today is that you and Miss Baker were together on Christmas Eve?
Portion of the day, I believe so.
You never shared with law enforcement the reason why Miss Baker did not spend New Year's with you, did you?
Tara did spend New Year's. She spent New Year's Eve with me until New Year's Day. Yes.
You never shared with law enforcement the reason Miss Baker stopped calling you the week of December 27th to January 3rd, despite being home. Is that correct?
What were the dates you just said?
December 27th to January 3rd, 2001.
I don't recall.
You never shared with law enforcement that Miss Baker told you that she needed space to focus on her studies 2 weeks before she died, did you?
Are you asking me? I'm sorry. There's a lot of questions.
You would agree that you never shared with law enforcement that Miss Baker told you that she needed space to focus on her studies 2 weeks before her death.
I'd agree.
And you also never shared with law enforcement.
Wait, she's finding his porn. She's apparently very upset by it, which, I mean, okay. That's its own thing. But, and then she's saying, I need space to focus on my studies. This is not sounding like things are getting towards engagement. This sounds like things are getting towards, yeah.
Meant that the day before Tara was murdered, that was the most that you two had spoken in the previous 2 months.
I don't know about that now. No, as far as did I say, I'm sorry, repeat your question. I'll make sure I understand you correctly.
You would agree that you never shared with law enforcement that the day before Miss Baker was murdered, that was the most that you two had spoken in the previous 2 months over the phone. I left that portion out, so please forgive me. Over the phone.
Okay. No, I don't believe I discussed that with the police. I wasn't really aware.
Would you have any reason to disagree that before Miss Baker died, others believed that it was clear that your relationship with Miss Baker was over?
It wouldn't be apparent or aware to me, no.
Let's discuss your dating history with Miss Baker. Is that fair?
Fair.
Okay. When you met Miss Baker, you two were in Milledgeville. Is that right?
Correct.
You two were in college.
Correct.
Okay. And you were a pre-med major. Is that correct?
That's correct.
And pre-med majors are typically aiming for medical school.
Correct.
Okay. And Miss Baker wanted to become a lawyer.
That's correct.
Eventually, Miss Baker graduated from college. Is that right?
That's correct.
And she moved to Athens. Is that correct?
At some point when she graduated, she moved home.
Yes, sir. But eventually she moved to Athens. Is that right?
Correct.
Okay. And you would agree after Miss Baker moved to Athens, you followed her to Athens.
Correct.
Let me frame it this way. You didn't graduate from college. Is that correct? You didn't get your pre-med degree. Is that right?
That's correct.
Now, for your living arrangements in Athens, you rented a empty bedroom in Chase Guerin's apartment. Is that right?
Correct.
And Chase is someone you actually met through Tara.
Correct.
And for work, while you were staying in Athens, you were driving back and forth daily to Loganville from Athens, Georgia to Loganville and back. Is that fair to say?
Yes.
And you moved to Athens specifically to be close to Miss Baker. Is that right?
Correct.
And when you first moved to Athens, is it fair to say that you and Miss Baker would spend in a 7-day week, you guys would be together about 4 or 5 days?
That's correct. That's pre-law school.
That's pre-law school?
That's before we spent that much time before she started getting in law school and getting more busy. Yeah.
So first semester of law school, you weren't spending 4 to 5 days with Miss Baker?
Well, yes, she would come by. Yes.
Okay. You would go to her house too. Isn't that right?
Yes. Yes.
And when that slows down, how's he feeling about that? Is he feeling good, or is he feeling like punching a wall, or a face? Because I mean, the guys who punch walls also often punch faces. If you got that kind of anger issues, yeah.
Towards the end of December 2000 and January 2001, Miss Baker stopped visiting your home that often. Is that correct?
So we get less time together. Yes.
Okay. And we've already discussed law enforcement talking to you about the incident that happened the week before her death. Would you agree with that?
Asking the question, yes.
Okay. And you would also agree that the week before her death is when you decided to go back to your parents' home for work. Is that fair?
Just for work, not to move. Okay. But yes.
So I just want to make sure we're clear. So you didn't move away from Athens before Miss Baker's death?
Correct.
Okay. So if anybody said otherwise, that information is inaccurate.
Correct. I have not moved.
And due to Miss Baker's studying and your work, the last time you saw Miss Baker was 10 days before she died?
Say it again.
It was 10 days before she died?
What was your full question?
Sure, I apologize. Due to Miss Baker's studying, as well as your work, the last time you saw Miss Baker was 10 days before she died.
Incorrect. The last time that I had stayed in Athens prior to her death would have been the Wednesday prior, but I saw her the weekend prior to her death.
And you saw her at your apartment?
No, she was at my parents'. She came by my parents' house.
And I noticed before you ask questions, you look over here. Is anybody communicating anything to you while you're on the stand?
No, sir.
Now, let me ask you about the question in regards to the 10-day window. You would agree that...
I'm guessing he's looking over at the prosecutor for help, right? And that's something that witnesses do sometimes. So basically, witnesses start feeling like they're on the ropes, and they sort of look over and they're like, help, you got to help me. And the problem is that this is something that looks awful and that can be called out by the other side. So I always tell witnesses, don't look at me. I'm not helping. If I meant to object, I'd have been objecting, but don't look at me like you want me to help, because all you're doing is making it worse and they're likely to dunk on you for it. So, yeah, eyes here is kind of what was going on there.
When law enforcement met with you, you told law enforcement in 2024 that you were certain it had been 10 days since you last saw Miss Baker. Would you agree with that?
I stated that in confusion. Yes, sir.
Okay. But you stated it. It was in confusion, but you stated it.
I stated it.
Okay. And Miss Elizabeth Bigham told you that she had your DNA. Is that right?
At some point, yes.
And she told you that because of the DNA that she had of yours, it could not have been 10 days. Is that correct?
Correct.
Okay. Ms. Bigham also told you that they need to be able to explain away your DNA. Is that right?
Correct.
And in response to Ms. Let me ask this question.
It's not good when the police are
In
saying we
response
need to
Ms.
be able to
Bigham telling
explain
you that
this
she needed to
away.
explain away your DNA. You continue to tell her that, no, I'm certain it's 10 days since I last saw Miss Baker. Is that right?
I started reflecting, and I do recall being with Tara the weekend before. I have always stated from prior to that I was with her the weekend before. Time had gone by, and confusion had started setting in, and I was reflecting on the last time I had stayed in Athens. But indeed, Tara had come to my house that weekend.
But you didn't say that you had seen her that weekend until Miss Bigham told you that you said that you saw her that weekend back in 2001. Is that right?
That's correct. And in other times beyond. Yes, sir.
And Miss Bigham told you that your DNA was found in Miss Baker's mouth. Is that correct?
That's correct.
And she told you the DNA doesn't last that long in her mouth. Is that right?
Correct.
She told you all of this information before you said that, hey, I remember now, I saw Miss Baker the weekend before she passed away. Would you agree with that?
Correct, I would say.
That,
But one thing
I
that
mean,
you were
there's a lot of
adamant about
hesitation
with Ms.
on
Bigham
that.
that she couldn't get you to change. You said, I did not see Tara Baker the week of her death. Is that right?
That's correct.
Okay, so I want to make sure we're clear for the record. You didn't see Miss Baker on Monday. Is that right?
Correct.
It's undisputed that you didn't see Miss Baker on Tuesday. Is that correct?
Correct.
It's undisputed that you didn't see Miss Baker on Wednesday. Is that correct?
That's correct.
And it's undisputed that you didn't see Miss Baker on Thursday.
Correct.
And it's undisputed that you didn't see Miss Baker, or you would say you didn't see Miss Baker on Friday.
I think it's undisputed.
So we have Friday, Thursday, Wednesday, Tuesday, Monday. So we'll say at least 5 days, right?
Correct.
Okay. And you told Miss Bigham that the closest time, for the first time, that you believe you saw Miss Baker last or had sexual intercourse with Miss Baker last was the Sunday before she left. Is that right?
Sounds accurate, yes.
Okay. And that was the first time in 24 years that you ever told law enforcement that you had sexual relations with Miss Baker on Sunday.
I think in the past I'd said it in the weekend, and I had said we had sex on Saturday, and I'm sure that I believe that we had sex on Sunday. It's just, yes.
That's a yes to my question?
I would say yes.
I mean, it's not looking good the way he's
So if
answering
you're-
things there.
I want to ask that question. So at the time of Miss Baker's death, you stated today, I believe, that you and Tara, well, I'll ask you, how long had you and Tara been dating at the time of her death?
Again, that would be 2.5 years.
Not 3.5 years?
2.5 years.
Not 3.5 years?
From 2.5 to, I think our 2-year anniversary was the July 4th prior. I believe that we considered us actually a couple.
Okay.
Yes.
So we'll say 2.5 years. So 2 years, 2.5 years. Within that 2-year window, you moved to Athens to be near her. We've agreed on that. Is that right?
Correct.
You helped her move into her Deer Park apartment. Is that correct?
Correct.
And at the time she moved into her Deer Park apartment, is it fair to say that you two were in a serious relationship?
Correct.
But Ms. Baker didn't choose to move in an apartment with you. Is that correct?
That's correct.
Did that bother
Before
you?
Ms. Baker died, you would agree that you two spoke 5 times.
Sounds right.
And we've agreed for the past 20 years, you've stated court's indulgence. Now, Mr. Melton, we've already agreed that in 2001, you were advised that Ms. Baker was sexually assaulted. Is that correct?
That's correct.
Okay, you heard it. You testified to it. Is that right?
Correct.
Okay. Now, you do recall also meeting with GDI again on May 5th, 2024. Is that right?
That's correct.
And during the May 5th, 2024 interview, you were told that someone else's DNA was found in Ms. Baker's mouth. Do you remember that?
That's correct.
Okay. And is it, you were told that it was the bad guy's DNA. Is that right?
That's correct.
You were also told by law enforcement that they did not intend to arrest you. Is that correct?
That's correct.
And they told you that they needed your help explaining away your DNA. Is that right?
They were trying to have an understanding.
No, they weren't. What they were doing when the police are like, hey, we're not looking to arrest you. We're just needing an explanation for this. I mean, this is often the police are just like, we want you to admit things so that we can convict you.
Of why the DNA was in their mouth or was in Tara's mouth. So, ask your question again.
Sure. They told you they needed you to explain. They needed to be able to. Let me rephrase it. They were asking you to help them explain away your DNA or why your DNA would be present in her mouth.
Yes.
Now, when they told you that there was another DNA profile in Ms. Baker's mouth, your response is,
May?
this is a little bit more than that.
Okay.
Come on, what are we arguing about? I don't think the
We've
defense
agreed
won
that
that.
you were aware that Ms. Baker was sexually assaulted in 2001, right?
Correct.
Okay. And despite this knowledge of her being sexually assaulted at the time of her death, your response was, I'm kind of stunned. I'm hearing there's two people, me and somebody else.
There's further description of that. I think they say in her mouth. Yes.
Make that statement.
And when they said in her mouth, yes.
Would it be shocking that if someone was sexually assaulted by someone else, that they would likely have more than one DNA profile in them? Is that fair to say?
Judge, I'm going to object for calls for speculation.
I'm going to sustain that objection.
In your personal knowledge, okay, if someone, whether by choice or not, is intimate with two people, you would expect that two people would be present. Is that fair?
If somebody was sexually assaulted, and I'm thinking that if it's in the vagina and around, Yes.
No. If it's in the vagina or what? Please finish that statement.
Right. What question was asked? Well, actually, how can I full have an explanation on the thoughts that are going through my head at that moment?
If I can ask you this, can you answer my question first, and you can explain anything you need to explain?
Fair enough.
Is that fair?
Just restate your question, please.
So I think we agreed on the point that you said you were kind of stunned. I'm hearing that it's two people, me and somebody else. We've agreed on that, right?
Yes.
And my follow-up question was, based on your personal knowledge, if someone is sexually assaulted by someone other than yourself, you would expect two people to be present. Is that right?
I would say yes, but I do have further explanation of my statement.
Sure. You were asked about your sexual history with Ms. Baker. Is that correct?
When can I continue to?
So I can answer questions. The honorable court is only giving
I'm
me
sorry.
authority to ask
Didn't
questions.
mean to look that direction. I apologize.
But the question I have for you, you have previously described your sexual relationship with Ms. Baker. Is that correct?
Yes,
And that did not include anal intercourse.
that's correct.
And when investigators interviewed you on May 5th, you understood the importance of being truthful. Is that right?
That's correct.
And you understood, and you told them that you and Ms. Baker never, ever engaged in anal sex. Is that right?
That's correct.
Okay. And just a couple more questions for you, Mr. Melton. Thank you so much for your patience. During direct examination, you talked about items on your hands. I believe you said it was plumber cement, it was solvent. What were the items that were on your hands when you met with police?
When do I get to go back and tell about the other? Refer to the previous.
I mean, if defense counsel gets their way, never. But okay.
Question that you had.
So the honorable court is only giving me authority to ask questions. After this hearing, you and I can discuss it if you like.
Not have an explanation to an answer. If I'm not, do I have the opportunity to explain a statement? If I'm not, I'm assuming I'm granted.
No, this is not your time, sir. This is not your moment. Yeah, you okay. All right. It's not how this works.
That I'm not sure about the order of the questions that he's stating that Liz and Jeremy had asked me, the order. Okay.
Objection, Your Honor, not responsive to any question that I asked. No question about the order of questioning
Okay.
by investigators.
Well, the reason.
Right, hang on just a second. What was your question again, Mr. Cruz?
I believe the question, and Mr. Melton can correct me if I'm wrong, that he would like to follow up on was the question in regards to his statement. I'm kind of stunned. I'm hearing there's two people, me and somebody else. And I believe he mentioned about it being in her mouth. And I think he wanted to follow up on that, Your Honor.
All right, well, witnesses are allowed to explain their answers if they answer yes or no. Did you, why don't you ask that question
But it's
again
like 20
and see
minutes
if you get
ago.
the yes or no question, and if this witness would like to explain his answer, he may do so.
Sure, absolutely. And despite knowing that Ms. Baker was sexually assaulted for 23 years, when you were told that somebody else's DNA was found in her body, your response was, I'm kind of stunned. I'm hearing there's two people, me and somebody else. Is that correct?
Correct. Okay. With the explanation. When Liz, they tell me, not that it's in her body, they tell me specifically that it's in her mouth. Okay. In my mind at that point, I'm not accurate about DNA and so forth, timing and so forth, but there was just a short fraction moment of a time. And if I can request to even play that section of the audio, that for just a moment, I was taking consideration that I say was this voluntary? Because why in the world would she not bite his penis? If somebody tried to do that, why would you not bite his penis? And that's what I was expressing.
So this is like, yeah. This is a mess. And this is like textbook rape myths, because that is not necessarily so like wow. I don't think this guy is doing great in front of the jury here, because yeah.
And I was in shock that it was in her mouth because for just a fraction of a moment, it kind of went through my head. I was like, was something happening there that I was unaware of with Tara? And I'm ashamed to even think that for a second. And then Liz responds, don't let your head go there.
Objection, hearsay.
It's on the audio recording.
Rejection. I've got objection.
That's abstained, Mr. Melton. So you can't mention what anybody else said. I would like to follow up on.
Okay. Yeah.
On the hearsay objection, Mr. Cruz in this line of questioning has specifically mentioned the words that the GBI agents are saying back and forth to Mr. Melton. So I think as it relates to the rule of completeness in this line of questioning, Mr. Melton is allowed to talk about that because of the fact that Mr. Cruz has opened the door to it in his line of questioning.
Would you like to respond to the objection about the rule of completeness?
I would. So the purpose of my questioning was the objective effect on the listener. So it wouldn't apply as hearsay because they give them information or they make a statement to them. The most important portion of it isn't what's said to him. We aren't offering that for the truth of the matter. We're offering it to the jury for his response. So anytime that I've mentioned something from GBI, it's either been a question that was asked, which is not hearsay because it's not a statement offered for the truth, it's a question, or two, the objective effect on Mr. Melton in regards to how did he respond to that information. The rule of completeness, from what I understand, applies to documents, videos, things that if you only play a portion of it or show a portion of it, it wouldn't put it into context. Now, if the state would like to, well, I won't get into that, but that's my understanding of the rule of completeness. Right now, we're just going through his testimony with non-hearsay statements from law enforcement.
Okay, I'm going to withdraw my former comment that it is hearsay. Both parties have agreed that it is not hearsay. I'm going to allow you to complete your statement. Go ahead.
All right, back to what I was saying.
I didn't agree that his statement wasn't hearsay. His statement was hearsay as far as what Ms. Bigum said. I was explaining my statements.
Well, I'm going to allow him to say
Yes, ma'am.
however you characterize it. I'm going to make a finding that both parties have said it's not hearsay. I'm going to allow you to continue explaining if you choose to do so.
Yes, ma'am. I'd like to continue. There was a moment when, I'm going to have to back up just a touch, I guess, but I hear that there's semen in her mouth. I'm expecting it in other places of her body, but in her mouth, I was like, how did she not bite this person? And for just a moment, I was like, was this voluntary? And then I was going the wrong thoughts in my head, and Liz picked up on that also, and she stated something that was beyond my realm of consideration, and she says, that's if Tara was still alive.
You were in her mouth too, is that correct?
It's the DNA. You're saying, yes, the DNA was located.
Okay.
Or that's what I've been told.
And I just want to make it very clear for the jury. When you met with law enforcement on May 5th, 2024, you understood that your DNA was in Ms. Baker's mouth.
That's what I was told.
Last question I have for you. I want to talk about your hands a little bit. Did you state you punched the wall 30 times?
I stated that I couldn't remember how many times I punched it, but I was just guesstimating.
Okay. But you stated that you punched it so hard that shingles were falling off the house?
No, that I was hitting at some point when I came through, I know I hit the siding.
Okay. Did you mention that you were hitting concrete and things of that nature?
Sir?
Did you mention that you hit concrete? Did I hear
Well,
that?
that's what the siding was made of.
Okay, so you were punching through the wall and hitting concrete.
Yes. I remember I remember punching through and feeling the other side. Yes.
You would agree that you never told law enforcement that you sought medical treatment for your hands. Is that correct?
That's correct. I never did.
Okay. And you would also agree that you didn't break any bones in your hands. Is that correct?
That's correct.
Okay. You also agree that the injuries to your hand were scratch-like injuries. Is that right?
There were scratch-like injuries on my hand. Yes.
I think we established this. This is my last point. I believe we've already talked about this and we've agreed on it maybe multiple times. But your hands were covered in work supplies when you went to meet with law enforcement, right?
Yes, I believe there was primer and maybe some glue that was on my hands.
You also mentioned cement as well, plumber cement, I think you said it.
Plumbing and cement, it's a possibility. I wasn't completely accurate of all this, but it's primer I know that sticks to your hands, and then there's probably little pieces of adhesive.
Okay, and I want to ask you something that's very interesting to me, and this is my last question for real.
Mm-hmm.
You refer to the officers by their first names. How many times have you met with them before this trial took place?
That's how they always introduce themselves.
My question is, how many times did you meet with them before this trial?
Before this trial?
Hmm?
When they interviewed me?
How many times?
Are you good buddies with them? Are they working with you to help stitch up a guy who didn't do it? That's where this is going.
I think I've had a total of 5, 6 interviews, I guess.
And that includes with the prosecutors as well?
As far as for the prosecutors, maybe 2.
Right, so they've met with you a total of 7 times, but they told you that your DNA was present in Ms. Baker's dead body. Is that right?
Who's you talking about? Liz and
Correct.
Jeremy?
Correct.
When they interviewed me?
Correct.
They said my DNA was also there. Yes.
Thank you, Mr. Melton. I have no other questions for you.
Any redirect, Mr. Yelnashilly?
Yes, Your Honor, briefly. Mr. Melton, I've got just, one, well, I'm not going to call it one question. It might turn into a couple, but just one thing that I wanted to talk to you about, because there's been some testimony about this incident between you and Tara, but there hasn't been any testimony about what that incident was. Can you explain to us, what it is that happened and what this disagreement that y'all had? And I believe you testified it was the only disagreement that you could necessarily recall that was ever serious. What was it?
Just bear with me. There was a time that Tara took care of me. I had gotten an infection. I had cellulitis.
So this is the big redirect.
That had entered my body through my thighs and through my buttocks on a job site late summer. Late summer, I remember it being hot. I had been shaved. I was on a new job site. I'm sitting on the soil installing plumbing. Well, during that time, evidently bacteria that had been in the soil entered through my clothes, entered my skin, and got me infected. That same day, later that evening, Tara was at my house, and she saw the effects it was having upon my body. And I'd swollen up in between my thighs and my legs, and my skin started turning black. She told me, you need to go to the emergency room. She took me to the emergency room. Once that was taken care of there, I had to come back to my place, and I could not walk or move around for a long period of time, possibly up to, if I can recall, 2 weeks. Okay. During that time, Tara was my caretaker. That's when she was given a key to get in and out because I could not go up and down the steps without having her come in to take care of me. Well, time goes by. Now I'm at the end of this, and I've healed up and I'm ready to go back to work. So she has stayed over. She stayed behind that morning to show herself out. Once I had gone to work, she had called me and said, we need to talk. And I said, okay. Well, she said she would meet me back at the house, meet me back at my place. While I was gone, what she had found I had a TV armoire with VHS tapes. And as embarrassing as it is, and this is something I had since I was 19 from back in college, she found an adult video. It wasn't anything crazy. It was just one video in bright orange.
Wasn't anything crazy. I'm like, okay. Okay. All right. Now you can tell he's rehearsed this, right?
Might add, so it wasn't concealed. It was just there. That hurt her feelings. She felt so disrespected. I was ashamed. I was embarrassed. I can't even quite remember the last time I had even seen it, but I was still in possession of it. She sat down in that argument and she demanded.
I mean, nowadays people would be embarrassed to have a VHS tape.
When did you come in possession of this? And then I further explained that when we were in college, back, I guess I'm 19 at this time, one of the cheerleaders was actually marrying another cheerleader. It was a man and a woman. They had been partners for a while, and they actually were getting married. Well, there was a bachelor party that didn't have anybody, no females show up or anything, but they had this adult video playing on the TV during that crazy little bachelor party guys kind of thing. Well, that's how I obtained it, because I asked the host, I was like, hey man, you mind if I have the tape? I was not in a relationship or anything at the time.
What? I'm just like, this is bold because I hey, that porno that you're showing, can I have it? Like, how do I just I need to know the mental processes that get from like A to wherever the fuck land this is, because I'm like, okay, so you've got a now I'll just explain. I played board games at my bachelor party, so like, I'm not exactly the guy to go to be like, all right, but just like, what what like, honestly, if he just said I bought a porno at one point and she found it and she was upset, like, that would be way. But this whole, like, I'm just like, huh? Why? Why? So, yeah. Rumors in chat that there was a tape, but it wasn't bought at a store, and it wasn't. Yeah, that might be a different scenario, as if and that would make a lot more sense, as if there was a tape that was not so much store bought. Yeah, that would. Anyway, this guy's coworkers are going to be going, so, like, if I work for this guy, you better believe that there's going to be an orange VHS, like, right, sitting on that guy's desk every morning for like the rest of time. I'm going to order those things by the crate just to like leave them around. So, yeah.
I'm ashamed to say that, embarrassed, but when she found that, I felt like I broke her heart. That was not who she was, and I hope it's not a representation really of who I am. I was a young man. She found that tape, and that was the only time I can ever recall that she raised her voice at me. And she demanded that I destroy the tape and throw it in the dumpster by my apartments with her hands on her hips, watching me. And I did. And we agreed, and I talked it out, and I laid everything out for her as she asked, and I was laying all my cards on the table. I was honest with her. She chose to show me grace, and she was understanding, and we made up that same day and in that evening. Okay. So
too many details.
As the time that I could have jeopardized our relationship.
When he says we made up that same day and into that evening, I'm like, yeah. I hate that. Thanks. Thanks for that.
And I've always shown her respect. And I didn't realize I was showing her disrespect in that fashion at that time, but she made it clear that that was inappropriate and that I should never do that again. And I agreed. And that's the incident that I explained to law enforcement when they asked me, is there ever a time that's what I hear. Is there ever a time that you have jeopardized your relationship? And that's what I tell them. I tell them that story. And that's the context of where that answer came from.
Judge, I don't have any other questions for Mr. Melton.
Any recross, Mr. Cruz? Go ahead.
Mr. Melton, you've gone to Ms. Baker's house with her before, right? We've agreed on that?
Yes, sir.
Okay, you've seen, it's fair to say that you would see her take out her key and unlock the door. Is that right?
Yes, sir.
So you would know what her house key looks like. Is that correct?
I guess it looks like a house key. Yes, sir.
And you would agree if you showed up to Ms. Baker's house unannounced, she would probably let you in. Is that right?
If I showed up to her house unannounced and knocked on the door and she answered the door,
Correct.
yes.
No other questions.
Any,
Hence lack of forced entry, right? Because so
redirect, Mr. Yamachili.
No, Your Honor.
May this witness be excused.
We ask that he is.
Any objection from the defense? You are free to go, sir. Ladies and gentlemen, we are going to take a lunch break. It is late, but we are going to take a lunch.
all right, so that's Chris Melton. And I'm like, huh. I thought the defense got a lot out of that. I thought the defense got a lot out of that, and I don't think Mr. Melton came off very well. Now, here's the thing. You do not have to walk away from that going, I think Melton is guilty beyond a reasonable doubt, because he's not on trial. But if the jury walks away from that thinking it could have happened, it could be this guy, then Faust walks, right? That's and that's where I'm at. Like, I don't know that this guy did it, but I also don't know that he didn't do it. And if I had to pick a guy right now, based on the information known about both of them, if I have to pick a guy, yeah, I don't know. I did not think that guy did well at all. So, all right. So let us move on to something a little. I don't know if I want to say happier. A little weirder. Little weirder. So let's. Oh, I'm seeing people say swoop. Swoop. All right, so let us look at let's look at some WestJet stuff, right? Let's look at that. So this is the case out of the Federal Court of Appeal of WestJet, an Alberta partnership, and TH. You might be saying, why is TH's? Yeah, we need more swoops. I got to get more swoops. Why is TH's name being initialized? Well, probably to protect everyone who isn't TH, because TH is awful. So what is this case about? This is a case about a creepy pilot, and you might have seen this in the news. The news mentioned that there was a creepy pilot story, but we like to go into the details. What is WestJet? WestJet is a Canadian airline. They're like, United kind of thing. Who is TH? TH is a pilot who formerly worked for WestJet. So WestJet seeks to set aside the decision of the Canadian Industrial Relations Board rendered on July 30th. In the decision, the board found that WestJet unjustly dismissed the respondent. So let us see, do we think that this guy was unjustly dismissed? So in reaching this determination, the board found that although the respondent made comments to a coworker about her breasts and often asked invasive questions to several coworkers about their and their children's sexual development that he knew or should have known were unwelcome, the respondent's conduct did not rise to the level of being sexual harassment. Yeah. What does the Federal Court of Appeals say? Well, they say, fuck that noise. They say this conclusion is unreasonable because it is at odds with well-established case law defining sexual harassment. We're going to see why, right? We're going to see why. The decision is also flawed because the board made contradictory findings as to whether the respondents' impugned questions and comments were sexual in nature. As the decision was premised in large part on the unreasonable finding that the respondent had not engaged in sexual harassment, the decision must be set aside and the respondent's complaint remitted to Mr. Asbill, if he's still available, or to another board adjudicator if he's not available, for redetermination in accordance with these reasons. So it's actually getting sent back to the CIRB. And but what are they fighting about? Neither WestJet nor the pilot wants to have them get better. And they don't want him working either. Like either of them, they don't want that. So the only question is basically whether TH is going to get paid for whether they're going to get paid for being fired. All right. So the respondent was a long service employee who had worked for WestJet for 23 years. He had a discipline-free record and received commendations for his work over the course of his career. At the end of his tenure, the respondent worked in a small department. The department was a close-knit one where the respondent, a coworker KS, and previous coworkers shared details about their personal lives. Very common in a workplace, right? But the respondent testified that he came from a family that was very open, where sex and sexual development were regularly discussed. What the fuck? He claimed that he was very interested in childbirth, female sexual development, details of breastfeeding, and related issues, and admitted that he often raised these matters with female coworkers. When KS joined the department, two of the respondent's previous coworkers, GP and AS, warned KS about the respondent and their interactions with him. KS, GP, and JD, another former coworker of the respondent, testified before the board about these interactions. These included the respondent's repeated comments and questions about the sexual development of the three women, their children, and the respondent's children. In addition, KS claimed that the respondent commented on the size of her breasts. The three women testified that they sometimes told the respondent that his comments were unwelcome and at other times indicated their displeasure by their reactions, including by walking away from the respondent to avoid unwelcome discussions. Despite this, the respondent failed to correct this unwelcome behavior and downplayed his coworkers' concerns. In addition, two of them detailed conversations they previously had with the respondent, where he described showering with his daughters when they were younger, that the two of them found troubling. Further, all three testified about incidents where the respondent reacted aggressively, including by speaking loudly, slapping his fists on a table, and lunging towards them when he became upset with them. The respondent also had personal habits that the three women found disconcerting, including picking the skin off his face and eating it when he became stressed. Okay, that's weird, but not harassment. So in April 2021, KS had a conversation with him that led her to complain to her manager. During that conversation, the respondent described his daughter's sexual development and commented on her body. The manager referred the matter to WestJet's people department, i.e. HR. And we have lost monetization. So send those super chats because we are not monetized, I'm sure, at this point. The manager referred the matter to WestJet's people department, which led to a formal harassment complaint against the respondent. It was investigated by two investigators who concluded in the report that the respondent, one, solicited information from his colleagues about their sexual development and their children's sexual development, asked female colleagues intrusive and inappropriate questions of a sexual nature, shared an inappropriate level of detail regarding intimate details of his family dynamic, demonstrated physical intimidation and aggressive body language and posturing, and retaliated against female colleagues. So, as a result of that, they shit-canned him. They fired him for cause. They're like, and you're going to leave so fast that you're going to fucking bounce. off the sidewalk on the way out, which is the right move, right? That is correct. But then he went and appealed that to the CIRB. And the CIRB then gets to make the determination as to whether or not his firing was legal or not. And if it's not legal, then he's going to be entitled to severance and all sorts of, or, if it's not justified, then he's going to be entitled to severance and all sorts of other things. Whereas if he was fired with proper cause, then he gets nothing, right? He gets to keep whatever sidewalk came with him when, when he left. So, all right, skipping ahead a little bit here. The board found that he had engaged in aggressive behavior, but concluded it was not serious enough to warrant termination. They also found that he had solicited information from female colleagues on their sexual development and the development of their children, etc. And they said, while he was never engaged in sexual touching or innuendo towards coworkers, and there was never a suggestion that anyone was concerned about that, his lack of boundaries and his inability to recognize the detrimental impact his choice of topics in conversation, that's one way of putting it, had on his coworkers, especially in relation to his own children and theirs and his coworkers' own sexual development, created an uncomfortable and unwelcoming environment and were inappropriate in the workplace. Yeah, I just further want to go a step beyond that and say, maybe like the police need to, maybe they should call the police, because I look at this and I'm like, he's asking about people's kids. I mean, he's lucky he's working with some pretty patient people, because I could absolutely, I could absolutely see this guy getting, basically getting, so, this guy is kind of lucky he didn't get any street justice, we'll go with that. So, yeah. All right. So they found that this was not sexual harassment. And so they said that he should not have been terminated. And they said that he instead should have been given a 5-day suspension. Now, the thing is that the way the court system works is that, having determined that his decision is unreasonable, they have to send the reassessment back to the original dude if he's around. And I'm like, this should go to literally anybody other than the original dude. And quite frankly, the guy who said that this was not like fireable, GRB, this is a Canada case. Yes, it is. The guy who said that this is not fireable, fire him too, right? Like, don't just fire the pilot, but also fire the CIRB guy, because, like, what the hell? What the hell? All right. So Westjet submits that the board's decision is unjustified in light of the applicable legal and factual context, and because the board did not follow a rational chain of analysis. I would say that the argument that they did not follow a rational chain of analysis is entirely like that fits to me, right? Because I don't see how you can rationally get from this guy's asking about people's kids in a sexual manner to he should not be fired. Like 100% fire that guy. And like, yeah, fire him, check his hard drive, and yeah. All right. So, so Westjet basically says they fucked up, they made errors. The respondent says, nope, the board's findings are reasonable and therefore should be upheld. So, analysis. Sexual harassment constitutes workplace misconduct that may warrant summary dismissal and should, depending on the severity of the conduct and other relevant circumstances. Employers in many Canadian jurisdictions have an obligation to develop and maintain workplace harassment and violence prevention policies, and employers may be liable for failure to take reasonable steps to prevent workplace harassment. What does that mean? It means that the employer can be sued. Like if Bob is working at a company and Bob is sexually harassing his coworkers, and the employer goes, it's just Bob, we don't care, then the company can theoretically be sued into oblivion, over failure to do that, right? So, yeah. All right. So sexual harassment includes a wide range of misconduct, ranging from sexual assault to comments of a sexual nature that the maker knows or should know are unwelcome. All right. So, examples: overt sexual advances, touching, peeping, viewing, and / or distributing pornographic material at the workplace. So if you have any of those old VHS tapes, do not watch them at work. As well as lewd, demeaning, and other unwelcome comments or behavior are all considered to be forms of sexual harassment. All right. So, continuing on, and they note, they're quoting from a different thing, and / or reference to women's bodies and questions about women's sex lives. All right. So, carrying on a little bit more, they note, from the foregoing, it is apparent that the maker of offending comments need not have been motivated by the desire to engage in sexual relations with those to whom the comments are made for the comments to constitute sexual harassment. Nor does a determination of sexual harassment require that the maker of a series of offensive comments appreciate they are inappropriate or that the person to whom they are directed object to them, provided that, when viewed objectively, the impugned comments are of a sexual nature and are offensive. And they cite some case law. Indeed, lewd comments and demeaning comments based on gender or sexual orientation have been found to constitute sexual harassment in the absence of any sexual intent on the part of the maker. So, likewise, distribution of pornography in the workplace in and of itself has been held to constitute sexual harassment. Wait, who the hell is doing that? So, yeah. So, they find that the board's determination is unreasonable, and quite frankly, I don't know that I need to go through the logic of this one, because the legal reasoning of why this is unreasonable is kind of, how do I put this? The court writes a lot of words in order to say, duh. Duh, right? Because of course these are harassment, right? So they say his repeated comments as well as his comments about a coworker's breasts did not amount to sexual harassment contradicts the well-established case law on harassment. These comments and questions were sexual in nature, were made repeatedly, and respondent knew or should have known they were inappropriate and unwelcome. Then the situations in which you should discuss this sort of thing at work is not even if they ask. Not even if they specifically request. So, yeah. All right. So the board concluded that he had mental health challenges. They say no issue there. But the court finds that the appropriate remedy is to send it back. Send it back to the same CIRB guy, or if he's not available, to a different one. And so I'm like, to a certain extent, this decision is the correct one, right? Because they're like, what the fuck? But to a certain extent, it's like, this decision is also super unsatisfying. Why is it unsatisfying? Because I would like to see the court just be like, no, I'm going to start writing zeros until my hand cramps. And that's the, that's the number. So, yeah, that's it. Check this guy's hard drive. And like, yeah. All right. That's kind of a depressing story. Let's go to Kelsey Fitzsimmons, which is maybe less depressing now. Okay, so only about 17 people sent me this case or this filing. And I want to thank all of you because it is, I'm glad to have it, but 17 people sent it to me. Oh, yes, I should read the super chats. Light Queens, good evening from Vancouver Island, Canada. I haven't been to Vancouver Island in so long. I should do like a meetup in Victoria or Nanaimo or something. That would be fun. I got to figure that out. Sandy, thank you for 10 gifted memberships. Honk Banana No, thank you for 10 gifted memberships. Melissa AU32, here's to getting lucky. We had the lucky. It was the beer. Thanks for covering the case. Georgia's nuts. I live there. I mean, yeah. Chris Mullen, go for it, Runkle. The truth will set you free. Thank you. Happy Monday. I missed catching your lives. I'm glad you're here. Lol, I'm guessing with Mrs. Runkle not being home that this is for a beer. It is for a beer. Confirmed. Law and Crime has purchased Court TV. I feel like that is a bad thing for many of us. You scored a good bottle of scotch. I don't currently have a good bottle of scotch. I've got some bottles. Can I say something that might make some people pissed off and upset? Okay, here we go. So I have a little bottle of Johnny Walker Blue Label. And the Johnny Walker Blue Label is mid-range. It's okay. I had a bit of it. I poured a bit of it, and I was like, all right, let's see what goes for like $400 a bottle. Because Johnny Walker Blue goes for like $400 a bottle. And I was like, I've had $80 scotches that beat out Johnny Walker Blue. Johnny Walker Blue is kind of dog shit for the price. I mean, it's, yeah. Ever have Johnny Walker white bottle? No, I wasn't actually aware they had a white bottle. I know about the green. I haven't tried the green. Johnny Osprey says, I'll give you $20 for it. It's just a little, like, small bottle. So, yeah. What is it? I have a Canadian whiskey you never recommended. Oh, right. You've got, like, I forget which one you bought, but it's not a good one. There are some good Canadian, whiskeys, but yeah, I mean, if you want some good Canadian whiskey, etc., I can find you a good one, but I don't know. Maybe sometime I'll do a Scotch tasting stream. And so maybe I'll have to do that and just bring out like a whiskey tasting stream and bring out like 10 whiskeys and get through and then get get soused. Ian, have you ever tried to make your own wine or beer? I made my own wine, but the wine we used, the yeast we used made it sparkling, and we didn't have cages on the corks. So we drank about half of it, and then the rest of it, like 8 bottles, the corks popped out, and oh wells. Yeah, a lot of it went to waste, unfortunately. So, yeah. Oh, I went to a dog event yesterday where they were selling $300 leather dog collars. Those weren't for dogs if they were $300. Dog collars are actually a bit of a pain in the ass. And I say that because I made a dog collar for Zora, and it lasted like 8 minutes. Zora, I made this lovely collar for Zora. It was like tooled leather. It was green with sunflowers on it. It looked great. It was wonderful. And she destroyed it in she destroyed it in like 8 minutes. So yeah. All right. So back to super chats here. Runkle gets lucky. You do the dishes. Were his hands noticed when he was asked to ID Tara, or not until the interview? I don't know when they were noticed, I'm afraid. PJ Wolfweimer is glad to be here. Glad you're here. The DA sounded like a defense attorney trying to debunk a police report. This is the problem. The DA, in order to make their case, has to show that Melton is innocent, which, yeah. All right. Even as a non-fighter, but as an RN, I could tell those hands were injured by punching a face-like object. Yeah. Thank you so much, Yikis Makaran. I hope I'm pronouncing that. I got the I Found God vibes a la SB. Sarah Boone. Also, Zero Tears. I kept expecting the Kintsugi speech. Lol. I don't like the judge much either. I mean, hey, if they do the Kintsugi speech, I will be impressed. Girl named Joey. I don't believe closed eye emotions. Yeah, this guy's a bit of a... Yeah. Thanks so much. Thank you. And thank you for the gifted membership. And thank you for 5 gifted memberships. And thank you for 20 gifted memberships, which makes me roll this. And Nick Starro saying, yeah, Mr. Melton is not a truthful person, in my opinion. I didn't see grief on the stand. I saw guilt. Yeah, that was kind of my feeling. And Mary Matilda May says, have a drink for me. Thank you so much. Much appreciated. I feel like we need to leave the laser eye spider crab caption silence basement dweller or pups, preferably pups. I think we could do the pups. Thanks for covering this case. Always appreciate your legal expertise and honesty. Thank you so much, Leah Baker. This is the Defend Chris's Meltdown trial. Faust not guilty. Yeah, at this point, I see a very difficult path to try to get to conviction. I'm like, I don't see it. So, I mean, we'll see. So I'd like a harder drink too. Enjoy. Thank you so much. Makes me happy that you went to make sure Zora was okay. Your love for your doggos is my favorite. Thank you for another great stream. I worry about the doggos. And the thing is Zora, I was worried that Zora might be outside because Zora is not built for Canadian winters. She goes outside and then she comes back in and she's like, I hate it. I hate the outside. Why? Why is the outside? And what do you call it? So Potter, on the other hand, this is Potter's entire, like right now, the cold weather is Potter's vibe. And Potter absolutely loves the cold. And so he'll go and he'll he'll sit in the, sit in the snow. He just loves that. Zora's like, I went out, I want back in. So, yeah. And Janaski, thank you so much. Much appreciated. Crazy Cat Queen, I had a VHS collection after working in Japan. Girlfriend asked to borrow them. I never got them back either. Lol. Fair. I dozed off and woke up to what sounded like Ian asking to keep Rob's special tape. Nope. That woke me up fast. I am pretty sure that Rob's bachelor party is not going to involve any special tapes. And certainly, I don't think it's going to involve any special tapes on VHS. Kyle Aiden Fox for the dog treat fund. Thank you so much. As long as I can join you in the stronger drink, I'm in. Let's do this to the goal. Thank you. I think that harder drink is definitely warranted. Thank you so much. The Daffy 9 says, and I almost missed the stream tonight. Thank you for making it. Glad to see you. I like Lagavulin 16, the only Scotch reference by name in the book and TV series, The Expanse. I haven't read The Expanse books. Maybe I should. But I really like the TV series. So, all right. So let's talk about this. So this is the case of Commonwealth versus Kelsey Fitzsimmons. And if you're wondering what this case is about, Kelsey Fitzsimmons is a Commonwealth police officer, and she is accused of like all sorts of things involving an allegation that she pointed a gun at a police officer. The thing is that the evidence so far that they've hinted at doesn't really seem to support that very well. But in the meantime, she's been trying to get bail and so forth. Is Potter named after Harry Potter? Yes. And this was before that became a controversial decision. But the reason why Potter was named Potter was because when we got him, Potter has this white mark on his head. And when we got him, it was very much a lightning bolt shape. Like super lightning bolt shaped. And so we ended up naming him Potter because he had the very much lightning bolt shape on his forehead. And then he got older. And his very distinctive lightning bolt shape became like a fuzzy blob. And so it stopped making as much sense. And yeah, now it's just a name that sometimes makes people mad. So, all right. So what is going on in Fitzsimmons right now is they have a defendant's motion to recuse Judge Kathleen McCarthy Naiman and a request for evidentiary hearing. So what does that mean? They want to kick the judge off of the case. They're like, this judge should be gone. All right. Now comes the defendant, Kelsey Fitzsimmons. By the way, some of the stuff in this is wild shit in here. Is Zora named after anyone? Zora is named after a court case. There is a court case, the Queen and Zora. It is a case about bail. And it was in my mind because the Zora case had just come out when we got the dog. And, it sounds good for a dog's name, but also, Zora is appropriately named because she is unable to keep the peace and be of good behavior. She's unable to abide by conditions, And boy, I hope Ian responds the way I did without law school. Oh, I suspect. Yeah, I suspect. Whoop. Trying to. There we go. Okay. So, as grounds, it is apparent that a reasonable, disinterested observer, being apprised of the facts of the judge's involvement in the case, would conclude that there is a lack of impartiality, or at a bare minimum, an appearance that the judge's impartiality might reasonably be questioned. So, yeah. Paddington Bear was named by Mrs. Runkle. Yes. Paddington Bear was named by Mrs. Runkle. Ripley was named by me. And so our rules for naming the dog is basically one of us comes up with a name and then the other one gets a veto. So I named the first dog Ripley. And Mrs. Runkle was like, okay, that's a perfectly fine name. We're good. And then the second dog, Mrs. Runkle was like, this dog is Paddington Bear. And I said, no, veto. No. And so you know what Mrs. Runkle did? She was just like, well, I'm still going to call the dog Paddington Bear, and that's going to be his name. And it's like, fuck. So I lost that one. And so the next dog was supposed to be one that I get to name because we alternate, right? And it's supposed to be I name the dog and then she gets veto rights and so forth. So she also named Potter. And it was like, damn it. Now, I got to name Zora through the magic of one particular thing. When we got Zora as, like, you know, she was a foster puppy, and so we went but when we were approved to get Zora, because you have to go through this whole like application process, you know, she's like a rescue mutt, but we had to go through this giant process. We had to send them pictures of our like backyard and stuff, and they were like, I don't know. So anyway, but they finally approved us, and once they approved us for the pup, Mrs. Runkle was busy at the time when we were able to go pick the dog up. So she's like, can you pick the dog up? And I'm like, can I ever twist my rubber arm? So I go and pick up this pup, and she was the sweetest, most loving thing in the car ride home, because she's like, I want to ride in your lap. And so I could not keep Zora out of my lap on the drive home because she insisted on climbing into my lap and going, gonna have me a little nap right here. And anyway, she was Zora by the time she got home. And when Mrs. Runkle, like, by the time Mrs. Runkle saw the dog, she was already very happy to, very happy with the Zora name. And yeah, that stuck. So she was stuck with it. So yeah. All right. So the instant motion is made pursuant to the Due Process Clause of the 14th Amendment and other law. So we're going to skip over it. And they say, here the record demonstrates multiple grounds, each independently sufficient and collectively dispositive, requiring recusal. So, all right. Request for evidentiary hearing. As the body of evidence required to be amassed in support of the motion likely includes, but is not limited to, probation officials, municipal third-party records, social media information, and the like, an evidentiary hearing and its attendant subpoena power is necessary to introduce the evidence and make sure the record is clear. They're like, we need a bunch of witnesses, and we need them here under oath. So, applicable standard. Judge must disqualify himself in any proceeding in which a reasonable person, knowing all the circumstances, would question the judge's impartiality. So, examples of situations in which I have seen judges disqualify themselves. I had a judge disqualify themselves because my client had been their client 10 years ago. And the judge said, I am disqualifying myself. I previously represented this person. It's been a decade, but I am disqualified. Cool. I had one where the judge disqualified himself because it turned out that one of the witnesses was related to him, not like directly, not like a sibling or anything like that, but was related to him like, in the sense of being like a niece's boyfriend or something like that. And so the witness, like the Crown was like, and now we're going to call this witness. And the judge is like, I might have a problem. And then the witness came out and the judge is like, yeah, I have to disqualify myself and I have to declare a mistrial because I have to disqualify myself mid-trial because I know this guy, right? But there's other circumstances in which a judge might be disqualified. Like, let's imagine that a judge is let's imagine that a judge is what do you call it? Heavily invested in, Bob Corp. Bob Corp is a major company and the judge is heavily invested in Bob Corp. Well, then it turns out Bob of Bob Corp is facing charges for, I don't know, drunk driving causing death. Obviously, the judge is going to be like, no deal, right? Like, I'm out because he's now got a potential conflict because if Bob is convicted, the judge could lose a ton of money, right? So, yeah. All right. The inquiry does not turn on the judge's subjective belief in his own neutrality, nor does it require showing of actual bias. This is important because when I have brought applications for, based on a reasonable apprehension of bias, usually what I'm arguing is, I'm not saying you are actually biased, judge, even though I might be thinking, judge, you're biased as fuck. But what you say is, judge, I don't think you're actually biased, but I think the public would have a reasonable apprehension of bias, and therefore you must recuse yourself because it's not just about all of this. It's, so, yeah. All right. Let's get past the standards and let's get to the allegations, because the allegations are the fun part. All right. So they've got some procedural history. Do we need to go with the procedural history? Poor dog was so embarrassed. The idiot was planning on breeding her to create his own sled team. He didn't know she was spayed. I mean, yeah, that's not going to go very far. All right. So, Ms. Fitzsimmons is before the Essex Superior Court, sitting at Salem in a one-count prosecution charging assault by means of a dangerous weapon under law. The judge presided on the case on August 14th for a bail petition in Superior Court, August 28th for arraignment, September 9th for a bail hearing, and September 11th for an emergency motion for immediate relief from scram. On both 14th and the 18th, the judge was assigned to Salem Civil A, Courtroom H, handling civil business in the Salem Superior Court. Nonetheless, she appeared and handled both the bail petition and the arraignment in the criminal session without any verbal or written explanation in court or on the docket. So it's like, you don't even go to this school. Why are you here? Right? Like, she's not even supposed to be there, is what the allegation is. The assignment sheet for September 2025, attached as Exhibit 2, also reflects her assignment to the same civil session. Nonetheless, she continued to leave the civil session and handle criminal business in the Fitzsimmons case, still without explanation. Without notice to the parties or the public, it appears she has specially assigned herself to this case, a one-count, simple 2 or 3 day trial, where a conviction warrants only a sentencing guideline sentence of straight probation. The assignment seems inexplicable on the merits of the case and raises questions about the motive of the court so as to undermine the public's confidence in the ongoing adjudication. Why are you taking such an interest in this case? Somebody else should have been there on those days. Why did you do that? So, grounds for recusal. Prejudgment reflected in a dangerousness finding and other pretrial matters. In upholding prior dangerousness findings and herself finding Ms. Fitzsimmons dangerous under the law, the judge has been privy to and has adopted as fact evidence that would not come into a trial of the underlying charge. The court has made a subjective personal finding that Ms. Fitzsimmons is a dangerous person. She has repeatedly referenced her belief, necessarily by clear and convincing evidence, that Ms. Fitzsimmons is an ongoing and present danger to her assailant, Officer Noonan, who needs the protection of a dangerousness finding from her. The court has also gone so far as to explicitly prevent any potentially favorable family court custody or visitation orders by prohibiting Ms. Fitzsimmons from seeing her infant child, regardless of any custody determinations in that court. This is a highly unusual finding, unprecedented in undersigned counsel's experience, that a superior court judge would impair the family court in performing its own core function of determining custody and visitation in the first instance. This court has gone far out of its lane in an effort to keep Ms. Fitzsimmons from her infant. So what I will say is that in my jurisdiction, in my local stomping grounds, what the courts will usually do is they'll say, Bob is not permitted to see his kid except as allowed by another court of competent or by a family court of competent jurisdiction. And so what they say is can't see the kid unless the family court allows it. And the reason why is because the family court is kind of the court with expertise here, right? The family court are, this is what they do. It's the same way as the court saying, well, I'm going to defer the question of what it takes to fix this vehicle to a mechanic. In this case, it's, it's a question of, you let the family court decide it 100%. So yeah. Bob Bobson says, objection. It wasn't me. I don't know about that, Bob. So the court's findings in these areas amount to an expression of her opinion on the character and guilt of the defendant. There are several relevant legal guideposts for the proposition that a judge who makes adverse pretrial findings on a case should avoid sitting as the trial judge. And that's what they want. They don't want this judge as the trial judge, right? So in Parento, the trial court's findings that the defendant was untruthful in the past and its failure to recuse at the jury trial was found to be an abuse of discretion by the appeals court. So, yeah. They note that a judge cannot partially recuse themselves. Once a judge concludes that there are grounds for recusal, he must completely dissociate himself from participating in the case. Ordering a jury trial, as the judge did here, does not substitute for allowance of a recusal motion. All right. So, in Parento, the court's pretrial findings regarding untruthfulness of a party were dispositive for recusal from the trial, and selection of a jury trial was not a remedy. The foregoing findings against Ms. Fitzsimmons are equally dispositive for recusal and are further supported by the present court's comments against counsel. Here, in its order dated September 16th, the court has alleged that defense counsel did not transparently provide information, resulting in a manipulation of the court relative to defendant's physical condition. The defense denies the claim and has not had any opportunity to address it. In any event, the court's personal conclusion in this regard gives the appearance, as well as the actuality of partiality on the part of the court requiring recusal, as was the case in Parento. Any other result would be an abuse of discretion. All right, so let's look at some additional findings, or some additional allegations. So, similarly, the reporter's notes to law relating to post-conviction relief address whether the trial judge who presided over a defendant's conviction should continue on the matter. While in the first instance, the case should start with the trial judge. The trial judge may bring to the hearing a prejudice that another judge would not have. Recusal of the trial judge should thus be liberally exercised, particularly where it is requested by the moving party. So basically, if there is an appearance of, partiality, get off the file. Thus, the rule recognizes that prior findings and proceedings can taint objectivity and that recusal should be liberally exercised, especially where the moving party requests it. All right. Finally, the court's demeanor and actions at the September 11th pretrial hearing provide ample grounds for recusal. So, Rule 2.3 says a judge who manifests bias or prejudice or engages in harassment in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Yes, Kelsey is out. Kelsey is out, and now they're just trying to make sure this judge doesn't run the trial. A judge must avoid words or conduct that may reasonably be perceived as manifesting bias or prejudice or engaging in harassment. This is part of why judges are so gentle. Like when I talk about this little subtle turn of phrase is how a judge is throwing shade. That's because judges are required to be gentle with that kind of thing. They can't just go and yeah. Yeah, it's a whole thing. Oh, also, I just got a member from my local one of my local city councilors. Can I go on a side quest? Chat, can I go on a side quest? Will you be okay with a side quest? Okay, here it is. So my local Edmonton city councilor, or one of the city councilors, put up a thing saying that so they want people to go and if they can clear out the they want them to clear out the little drains that deal with the melting snow runoff. And so they're offering free tickets to the zoo if you take video of yourself clearing out one of those things, right? So I asked, can I use my flamethrower? And so my city council was like, or my city council member was like, no, you cannot use your flamethrower. You can't use a 9mm. You can't use any of the stuff in your toy chest. Because he also knows who I am. Like, he knows that I've got a YouTube channel and all of that. So he's like, no, Runkle, don't. No flamethrower. And I mean, it is the answer that I was expecting, but it's especially funny when he's like, you also can't use the 9mm. And I'm like, government. All right, that's the side quest there, and yeah. So a judge that who considers prior adverse findings through plea negotiations should not sit on a trial for that same litigant. All right. Now let's go to some of the other allegations. Personal and economic interest creating an appearance of bias. And you're not wrong about the Edmonton City Zoo being kind of crap, but yeah. Basic internet research shows that Judge McCarthy has resided in the town of North Andover for approximately 25 years. Public real estate records indicate she is a listed homeowner in the town. She was the founder and principal of the law offices Kathleen M. McCarthy, a criminal defense firm in North Andover, and is listed in Massachusetts Lawyers Weekly 2020 as a former sole practitioner in North Andover from 1997 to 2018. I'm like, doing research on the judge is a risky freaking move. In adjudicating the alleged dangerousness of Ms. Fitzsimmons, what is it? a fellow North Andover resident in a North Andover incident, the court inevitably had to consider the safety of herself, her own family, and former colleagues that work or live in the town. As a tax-paying resident, the judge has a vested interest in the financial security of the town and its reputation in the Commonwealth. I'm just going to say here right now, I don't think this argument is going to fly. She has bias because she lives in the town. Nope, this is never going to go anywhere. This argument is dog shit. Sorry, it is. So Fender, an hour behind, but you did board games at the bachelor party because you actually like your wife. This is rare, apparently. Yeah, I did not want the I didn't want the like stripper board or stripper, bachelor party. I have never had any interest in never had any interest in strip clubs or anything like that. I've been brought to strip clubs on a couple of occasions, and both times I just was like, how soon can I leave here? Because they are the worst. Just, and yeah, they're really an unpleasant kind of environment, right? I don't appreciate them. What is it? Hire a stripper to play board games fully clothed. That I have done without having to hire anybody. So fun side quest. So I like D&D. I like tabletop role-playing games. I like all of these things. And so a not direct friend, but like a secondary friend, like friend of friend, reached out and was like, hey, me and a bunch of friends have never played D&D before. Would you consider running an adventure for us? And I was like, sure. Anything I need to know? And she says, nope, just a group of friends. And I was like, okay. So I show up. I've got like D&D books. I've got dice for a bunch of people. I've got screen. I've got whatever. And I am sitting down with a bunch of women who are like really attractive women. And I'm like, what is going on here? Because I will say it is very unusual in the D&D sphere to find groups that are entirely women. It's, normally you find a lot of male-only groups, but this group was entirely like, and not just entirely women, but like entirely women of like a very particular build, I guess. And so I was like, what? And it turned out it was a mixture of different varieties of sex workers. So be that, strippers and beyond. And I was like, okay, cool. That's here we go. And we had a great D&D adventure. And it was just like, all right, because that's what everyone was there for, is D&D. And we had a good time. And they were like, yeah, this is cool. And I was like, yep. So it was a fun random adventure. If you're wondering like what the adventure was, the adventure, I reuse adventures. And so there's a particular adventure that I have reused a number of times that involves like going and attacking a kobold tower. No, after Mrs. Runkle found out afterwards, because I found out afterwards. I was just like, hey, I'm going to go run a D&D game. She's like, have fun. And I came back and I was like, hey, so the D&D game was weird. She's like, tell me about it. And I was like, here's how it was weird. She's like, okay. Did you have fun? Yep. Okay. Because Mrs. Runkle also trusts me. So yeah, there's no, I was just like, hey, She's like, cool. Was it fun? Like, yep. She's like, so yeah. And I mean, there was nothing weird or unusual about it. It's just a bunch of people from, particular sort of subset of occupation. Do I know if the women kept playing? I don't know. So I don't know at all. But yeah, they wanted partially to learn to see if they'd want to do it. And then, so I suspect they may have bought books if they were so inclined. But all right. So on the unique facts of this case, one North Andover police officer, Patrick McCarthy Noonan, shot and almost killed another North Andover police officer, defendant Kelsey Fitzsimmons. By the way, I'm pretty sure that the reason why I got invited to do that was because I am like 0% likely to hit on anybody because, so I'm the safe choice. So the police immediately adopted and believed the story of the shooter officer and never sought to interview Ms. Fitzsimmons, who fought for her life for 53 days in Massachusetts General Hospital. The case involves only these two officers as percipient witnesses with no body camera video. The defendant has potential civil liability claims arising from the conduct of government actors in this case, claims that could foreseeably expose North Andover to substantial financial liability. Municipal tort liability directly implicates municipal finances and taxation, and as a resident property owner, the judge has an economic interest that could be affected by the outcome of this criminal trial. Such an interest is disqualifying where it might cause a reasonable observer to question impartiality. You have got to be shitting me here. You've got to be shitting me. Didn't you once pay strippers to not to bother you? That is also correct. On one of the occasions when I've been dragged to a strip club, I basically gave a bunch of money to one of the strippers and was like, can you just circulate word that like I just want to be left alone, and like pass me over for the lap dance, circle. I'm not gonna be like, yeah, I'm just gonna be sitting at a table like having a drink and just like, yeah. So all right. The thing is that like if Kelsey Fitzsimmons wins a civil proceeding, the judge's financial like impact is probably going to be dollars a month. And yeah. It was pretty much like, here's all my money. I am not, I'm tapped out, and yeah. So another Essex Superior Court judge, Kristen Buxton, recused herself in similar circumstances as a taxpayer in the town of Ipswich in the manner of Copethorne versus town manager of Ipswich. Copethorne was a taxpayer suit. Yes, this one is directly connected to the taxpayer suit, not indirectly. I think there's too many steps here. Yeah, I don't think this one's going to go anywhere. Frankly, I think the judge is going to toss that part, and yeah. Now, this part, I was like, what? What? This part is the part where I went, what the actual fuck? So here's the thing. Undersigned counsel has recently been informed that Judge McCarthy Naiman had an ex parte and undisclosed conversation with Assistant Chief Probation Officer Jeff January. Remember Jeff January? He was the probation officer who, yeah. Oh, somebody's saying read that footnote. Footnote, discovery documents provided by the Commonwealth relative to Noonan's training list has his full name as Patrick McCarthy Noonan. It is unknown and undisclosed by the court whether there's a family relationship. I wouldn't suggest family relationship unless I actually had, yeah. That's how I tip at open bar weddings. Hand the bartender a 50 at the start of the night, introduce myself, and I don't wait in line. My drink always ends up ready as soon as my glass is empty. That is actually a winning strategy at open bar nights. And, yeah. Yeah, this, you don't pull that trigger of suggesting there's a family connection unless you know. And you can hire PIs to find that out, right? So, yeah. All right. So Jeff January was like, he testified at that bail hearing. And they say this conversation occurred the day before the court sua sponte revoked Ms. Fitzsimmons' bail and returned her to custody, cut off defense counsel, invited objections from the Commonwealth, walked off the bench when counsel was addressing the court, vilified ACPO January in open court, and was visibly shaking and angry. Counsel was informed by ACPO January and his attorney that Judge McCarthy Naiman came to his office unannounced the day prior to this hearing. She sought to investigate the status of Ms. Fitzsimmons' compliance with probation terms and was informed by ACPO January that there was no violation. The judge should not, under any circumstances, should not be speaking to witnesses ex parte. She should, like, this should only be happening in court with both sides present and able to, yeah. So ACPO January recalls that he discussed the fact that he had email communications with undersigned counsel, which appeared to upset Judge McCarthy Naiman. When ACPO January mentioned that his emails, favorable to the defense, were likely attached to the motion filed for relief, McCarthy Naiman abruptly left ACPO January's office. There was no legal justification for the court visiting his office and conducting its own investigation outside the presence of defense counsel, off the record, and without subsequent disclosure of the defense. That shit about she lives in town? Who gives a fuck? I do not give a fuck about lives in the same town. Like, I just don't, right? But this shit about she went and was doing her own investigation the day before the hearing, that is like, this part should have been the front of the motion. And quite frankly, I would have cut out all of the lives in town shit. I just would have cut it out. I see somebody saying, but it's relevant. It's not relevant enough to me to, like, I wouldn't. I would not. I would leave that out and I would attack on the strong ground. So, I mean, you know, I just, that's where I sit on that one. Right. And I see we've got a couple of things here, that are PayPals that I got to mention while I've got KPT says, KPT here. Thank you for covering Faust. This is wild. I thought my country, was better than this in 2026. Sadly, I was wrong. Yeah. I mean, it doesn't feel good for a lot of people. NC says, for the dog treat fund, thank you so much. And Heidi says, cheers from her giraffe gal. So, yeah. All right. If you really want to preserve all other arguments, you can always cram them into the into a bad run-on sentence at the end. I mean, if you want to put the town argument, you put the good argument first, front and center. You put the shit argument in the middle, and then you come back and you revisit the town argument, right? What's an ACPO? Assistant Chief Probation Officer. So, yeah. Julie and I would like to motion for pigeons. Motion is granted. By the way, I found something that I meant to, like, sell. So ages ago, I bought some pigeon pins. You know what? Let me go get them. I'm just going to go get them. I will be back in just like 0 seconds. Wait here. All right, some people could hear the door, so they know I'm back, but I can't yet have my ears in. Man, this music is awful. I'm sorry. Okay, so what is it? Some channels have like an entire merch team. I do not have a merch team. I instead have me effing around and trying my best. And my best is very attention deficit guided. And what I mean by that is that I bought a bag of these things figuring I'd sell them, and for just a few bucks a pop. And then I forgot about them. And they got put in a drawer to get them sort of out of the way at some moment. And so I completely forgot they existed until Mrs. Runkle was like, "Why do you have pigeon pins?" Now, Mrs. Runkle doesn't watch my streams because she's like, "I get enough of your voice like every day." And she's like, "I don't need more of that." So I'm peeling the protective layer off of this thing just so I can show you the pin. But that's the pin. It's a pigeon with a backpack and a suitcase. And it's so I need to get off my butt and actually sell those. But yeah. Yeah, I've been bad at all of that. So, all right. What is it? I get enough of your voice every day. That's love. One of the things Mrs. Runkle likes least about me is my explanations of things, because how do I put this? I'm used to explaining things on YouTube and just in general. And the thing is that when you explain things to a group, you have to explain them as simply as possible, because otherwise, like if you explain them at a high level, you'll get lots of people going, I don't know what's going on. So when I explain things to Mrs. Runkle out of habit, she's like, "I'm smart though." And I'm like, I know. God damn it. I know. Sorry, it's habit. So I have to back myself off of explaining things because it's habit. And so yeah, Mrs. Runkle is like, so I got to be careful, right? And explaining why his wife doesn't like him explaining things. I mean, you're not wrong. You're not wrong. All right. So, and sometimes I explain things like over much because I'm talking my own brain through it. And so sometimes it's not even like I'm explaining for the other person. It's that I'm explaining for myself. And that also doesn't go over well. So, all right. So, These ex parte communications concern matters bearing directly on the defendant's liberty, which was at stake, unbeknownst to defendant, the very next day. Such conduct directly violates Rule 2.9, prohibiting ex parte, i.e., outside of court, outside of the other party being present, communications. Where a judge receives information outside the adversarial process and then presides over related proceedings, the appearance of impartial adjudication is irretrievably lost. I think this one is a showstopper. And quite frankly, the judge should be like, yep, I'm recusing just to get that out of this. So, yeah. Personal embroilment with probation and defense counsel. Undersigned counsel was recently informed the September 11th hearing on the emergency motion for relief. The judge filed a complaint against ACPO January arising from this case. This is despite her unclean hands engaging in ex parte conversations from the probation office. I have never heard of a judge filing a complaint against a probation officer. That is wild. Upon information from ACPO's January's attorney, the complaint filed by McCarthy included accusations of defense counsel colluding with probation. As a result, defense team members are now supporting witnesses for ACPO January against the judge in this complaint that directly stems from this very case. She's got to recuse. Like, this is insane. Also, it is not inappropriate for defense counsel to speak to probation. I'm a defense lawyer. I talk to probation officers all the time. Hey, my client fucked up. They got themselves kicked out of this treatment facility. Can we find them another treatment facility? And the probation officer's like, again, it's like, yeah, I know. Client's got, some sort of issue. So, like, what can we do? Can we work this out? Like, this kind of conversation you have all the time, all the fucking time. Hey, my client called me. He wanted me to call you and tell him gonna be late, right? He's on his way to the appointment, but he's gonna be late. All the time, that sort of stuff happens. So, yeah, I mean, this notion of colluding is, yeah. Runkle, do you do Runkleisms with Mrs. Runkle? Yes, I do Runkleisms in all sorts of situations. Like, do you explain things starting with a guy named Bob? I don't usually do the Bob thing because I try not to explain stuff. But I have, I sometimes do other kinds of Runkleisms. So, yeah, and some of the weird turns of phrase I come up with have become like in jokes in our relationship. So it's a thing. All right. At a hearing on the ACPO January probation matter, undersigned counsel would attack this court's position and credibility and assert the court's complaint is false, baseless, and merely dissatisfaction with an undesired viewpoint from probation. In fact, counsel would also assert that ACPO January at all times acted fairly, truthfully, and professionally. Mr. January did everything he could to accommodate Ms. Fitzsimmons' disability, unlike the court itself, and deserves praise in the full support of the probation department, rather than an assault on his reputation. Like, they are contradictory witnesses on a different file. How could she possibly stay on? Further, the court's complaint is proof that the court's foray into ex parte investigation before the hearing simply didn't produce the desired information and resulted in the court vilifying ACPO January the next day at the September 11th hearing without any cause whatsoever. In addition, and perhaps most compelling for recusal, the fact that the court did not disclose this complaint to counsel for Ms. Fitzsimmons is strong evidence of the judge's bias and lack of impartiality. A judge who has entered the fray, particularly by leveling accusations against counsel of record and court employees who provide good faith assistance to defense counsel, cannot thereafter preside without creating an appearance of partiality. The court must recuse. Like, why did they start off with the whole address shit? She lives in town. Like, no, this This is the same. So based on all the foregoing, many questions have been raised that create a scenario where the judge's impartiality might reasonably be questioned. Answers require an evidentiary hearing to obtain facts that would likely show her impartiality is compromised. These questions are limited to, but not limited to the following. So these are things they want to ask. Is the judge related to Patrick McCarthy Noonan? If that turns out that she is related to Patrick McCarthy Noonan, then she should be defrocked. Like not disrobed, because that is a different thing. But like removed from the bench. Like absolutely removed from the bench if that, if it turns out that's the case. Why is the judge covering every hearing on this case through the trial? Is there a written order to that effect? Why did she repeatedly leave a civil session to cover this matter? What specifically is in her complaint to the probation department concerning the ACPO January's actions? Why didn't the judge disclose the existence of a probation complaint involving the defense on Ms. Fitzsimmons' own criminal matter? Why did the court have an ex parte meeting with ACPO January in his office? Why didn't the judge disclose the meeting and comply with the Code of Judicial Conduct? Did the judge use any inside information obtained against Ms. Fitzsimmons? Why is defense counsel's advocacy perceived by the court as manipulation or collusion? Why is the court using such descriptives which are indicative of bias? So they want her off the... I will tell you what I would do if I was this judge. If I was this judge, I'd be like, I am denying your request for an evidentiary hearing, but I am granting the recusal motion. I'm off the file. I'm gone. And goodbye. Goodbye. I would be like a roadrunner shaped puff of dust, right? Just like gone. Just gone. So gone. I mean, parts of this filing I think are not very good. Sorry, Bradle. I don't like the "you live in this town." I would have left the "you live in this town" right out. But other parts of it are like spectacular. Spectacular. So, I mean, we'll see. Who hears this motion? Not her, is it? It's her. She hears this motion. She will make the decision. And yep. So, but if she denies it, they can theoretically take it to a higher court and so forth. So, all right. Phoenix Paw. If I get a dog, it'll be named Grandpa. Love it. As a member of the public, I perceive bias here. I am shocked at these allegations. I've gotten judges recused on much less than this. So, yeah. When sheriff arrives to enforce the eviction order, will he kick my ass? I've seen one eviction. They arrive to knock with the battering ram ready to go. Depends on jurisdiction. Some jurisdictions are nicer about that than others. And yeah. Honk Banana No was my late sister's birthday yesterday. I am sorry. I leave the Christmas tree up for every year, tradition. Now it's time to take it down, and I'm bummed again. I'm sorry, Honk Banana No. It's a lovely tradition, but yeah, I hate the reason for it. Fender says during a sexual harassment hearing against a prof, and that was fucking traumatic. The whole point was intent doesn't matter if behavior was inappropriate. 100%. 100%. And Music to My Soul says the nerve of the judge to be in the midst of an ex parte investigation and still get offended that counsel had emailed the same person she was meeting. Right? I can meet them in their chambers, but you have to, but you can't even email them. My dog is Luke, as in Skywalker. He's 132 pounds, and you don't have to bend to scratch his back. So Potter is a big boy, and So the other fun thing with Potter, so earlier today I was taking a nap, and Mrs. Runkle stepped out to run some errands. And so when she stepped out to run errands, Potter and Zora both decided that was the time to have snuggles. And collectively, with Potter on one side and Zora on the other, I was sandwiched in between dogs, which sounds great because it is. It is literally the best. But there was a lot of dog. And yeah. All right. So let's do a swoop. And the swoop we need is where's the swoop? I need the swoop. This one. The robot lawyers swoop, because once again, lawyers continue to use AI, and it continues to blow up in their face. And the number of lawyers who've had that problem is tremendous. And it's going to continue to be tremendous because that is what lawyers do. Yeah, it's just there's a lot of lawyers who are like trying to shortcut things, who are trying to, and basically lawyers are busy. And so you're like, if I can get this done faster. But the other thing is that lawyering is stressful. Lawyering is hard. So right now I am self-represented on a file. And this file is with a guy who I previously mentioned on this channel, the guy who, who the police think wants to kill me, which is like a really bad idea because I do not recommend trying to kill Runkle. Runkle is going to, Runkle might be difficult to kill. So just saying, don't. But, this guy he wants to appeal the court case that, amongst other things, provides protection to Runkle. And so I have to, I have to file something in that. And I don't want to hire a lawyer for it, because if I hire the lawyer for it, it's going to be like, it's going to be thousands of dollars. I am thousands of dollars in on my Illinois case, with a particular lawyer who will not be named for this moment. But, she's cost thousands of dollars on that. And yeah. So at the end of the day, I'm just like, I'm self-represented on that one. But it wouldn't matter if I was self-represented or representing a client. Regardless, you write stuff and you read over it and you're like, is this good, or is this the dumbest shit I've ever seen? And I rock the imposter syndrome really hard because I still I look at cases that I've won and I look back at them, and I've read my written submissions on those and gone, man, those suck, right? And I'm just like, I hate everything. So yeah. Camper for Life says, crowdfund the lawyer fees for Janet case. If Janet's case starts becoming really expensive, and then I might. But right now, Janet is right now her case is manageable for cost. And the thing is that of all the people, like if you're sitting there going, I want to donate to one of the, donate to their fight, donate to like the, Caffeinated Kitty and, the Do We Know Them, girlies and so forth. Cause I'm okay for right now. Like I will be all right. Whereas, like, you know, so Janet picked a fight with me, and I'm in a better position to fight, to fight back than some of the other people she's fought with. And I mean, depending on what she decides to do, it may end up being that in future I need to say, hey, I need some cash, I need help, right? That may come up in future. It might be, I need help, but I'm not there yet. And until I'm there, I'm not going to be reaching out going, I want money, because I'm okay. I am able to deal with that and so forth. So, and I mean, her legal fees just got cheaper because she just like lost her lawyer. But yeah, I will tell you more about that one day, probably. All right. So Against the Tide says, please like y'all. Also, please check out Roll of Law. I have got to do a video for Roll of Law. It's been a while since I've done one. And yeah. Also, have you heard of the movie Mercy, AI Judge? I watched Mercy. Me and Mrs. Runkle went and watched it. The court process parts of it pissed me off. But the movie was actually pretty fun. So I liked the movie. It just, yeah. Yeah. KPT says, holy cow, it's been almost 3 years. Seems like forever. I did not expect to be still doing this, but I'm happy to. All right. So let us go to this case. So, Flycatcher Corp and Flycatcher Toys Incorporated versus this many people. Many people. Affable Avenue, Osmos Company, Eitan Grossman, Creative Rewards Incorporated, Joshua Chavez doing business as One Stop Fast Shop, Toy Experience Company doing business as We Pay Cost, Pretty Princess LLC doing business as Norvy, and so on 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 and so on. All right. And John Doe's 1 through 25. Okay. So what do they say? And this will be short because this is a robot lawyer's case and we're not going to get it too much into the weeds. But in June 2025, Stephen A. Feldman, counsel for defendant Affable Avenue, filed a brief in support of Affable's motion to dismiss that was peppered with false citations. Concerned about both the genesis of these misstatements and counsel's delay in correcting them, the court issued an order to show cause. So the court is like, there's a bunch of bullshit. This looks like AI. And show me that this wasn't AI. Show me why I shouldn't. Like, basically, the court is sitting there going, I have a big hammer. Show me why I shouldn't hit you with the big hammer. Right? Tell me why not to hit you with the big hammer. And so, perhaps not appreciating the gravity of the situation, Mr. Feldman responded to that order with a submission that appeared to have been created by generative artificial intelligence and that itself contained a false citation. When the court is like, I am ordering you to show cause as to why you should not be held in contempt for using AI. That's not the time to go to the law firms of Grok, ChatGPT, and Gemini. Like, this guy, yeah. So the court's response was stern and unmistakable. Mr. Feldman was not excused from this professional obligation of verifying that the cases he submitted to the court were valid by dint of using emerging technology. In fact, that's when you have to use it even more. So, Mr. Feldman persisted. A few days prior to the court's hearing on the order to show cause, Mr. Feldman submitted a proposed reply brief in further support of Affable's motion to dismiss. Once again, his brief contained false citations. And at the August 22nd hearing, Mr. Feldman was unable to respond to directly to, much less answer, the court's questioning about his submissions. Mr. Feldman has not, and apparently cannot, learn from his mistakes. This is the kind of language you do not want a court using to describe you. And while the court does not oppose the use of AI to assist in legal research and writing, it must take a stand where, as here, counsel repeatedly files submissions with false citations because counsel refuses to verify those submissions. This court can do no more. For the reasons that follow, the court sanctions Mr. Feldman pursuant to Federal Rules of Civil Procedure 11 and the court's inherent powers by striking Affable's submissions and entering default judgment against it. So what this means is that the defendant, Affable, has just lost the case. They have just had judgment entered. And so the only thing, and so they're going to have to pay a whole bunch of money because their lawyer fucked the dog. And so you know what Affable is doing next? Affable is turning around and suing the absolute shit out of this dude. And so if Affable ends up owing like $500,000, they're suing this lawyer for $500,000 and saying we should have won this, but for his legal malpractice. And so his insurance carrier is right now going, oh shit. Oh shit. So background, plaintiff's complaints and defendant's motion to dismiss. So Flycatcher filed a 5-count complaint alleging federal claims for trademark infringement, unfair competition, as well as state and common law claims for deceptive trade practices, fostering the sale of stolen goods, and unfair competition. Over the next year and a half, they amended their complaint several times before eventually filing a third amended complaint on May 23rd. They filed separate motions to dismiss the third amended complaint, and that is where the trouble began for Affable's counsel, Mr. Feldman. Top alerts Affable in the court to disconcerting errors in Affable's brief. So counsel for Top, that's the other side, the plaintiffs, Joel McMull, submitted a letter to the court expressing concern that Mr. Feldman had used an artificial intelligence large language model such as ChatGPT to write his brief, resulting in significant errors. In particular, they alerted the court to a series of faulty citations in Affable's brief, at least 13 cases Mr. Feldman cited that did not exist, and 8 cases that did exist but did not contain the quotes Mr. Feldman attributed to them. So, this is the problem with generative AI. Generative AI it's a bullshitting machine, right? It's absolutely like, you ever gone to a bar and there's a guy sitting there and he's got like 3 empties and a full beer in front of him, and he'll tell you some story about gerbil facts or something, and it's complete bullshit, but it sounds good. Well, that's what generative AI does. It just makes shit up that sounds that sounds good in context, but may be complete garbage. And so, there are things that generative AI is absolutely, useful for. But if it generating garbage is something that can cause you or somebody else harm, then you shouldn't use it, at all. All right. The other thing is that generative AI is really a dog shit substitute for actual creativity. So if you want actual human, yeah. All right. So Mr. McMull detailed not only the errors he observed in the Affable brief, but also his efforts to get Mr. Feldman to correct them. Before submitting his letter to the court, Mr. McMull had emailed Mr. Feldman on June 22nd to notify him of the citation errors and to express concern about his potential misuse of an AI large language model. Mr. McMull requested that Mr. Feldman file a letter with the court by 5:00 p.m. the next day, withdrawing Affable's motion and brief explaining to the court his reasons for doing so. If he did not, Mr. McMull said that ethical obligations would require TOPS attorneys to report their concerns to the court. By the way, if you ever get an opportunity from another, lawyer or a judge saying, hey, we're going to let you own up to this shit, it's usually a good idea to do it. So, yeah. Lee Chan saying, if you're an artist, protect your art. Glaze and Nightshade, both are free and Poison's AI. They also both kind of tend to make things look like shit. So, yeah, I'm not a big fan of those tools, but yeah. Mr. Feldman did not comply with Mr. McMull's request. Rather, he replied to Mr. McMull's email the next day, offering a convoluted excuse for the errors, one that he would later repeat to the court, and claiming that he was unable to verify certain citations due to discontinued access to certain legal research databases. So, let's talk about legal research databases. I have a subscription to Westlaw that I barely use, and it costs me like $130 a month. I am thinking of canceling it. Westlaw is slightly better than Canly for firearm stuff. However, it's like $130 a month, and that's them cutting me a deal because I'm one person who uses it not much. But you know who has all the legal research databases? The law library. You go to the law library, they've got Westlaw, they've got Quick Law, they've got, all the things. And they have all the, they have all the add-ons and whatever else. You can do all sorts of things. So, I mean, if you ever need to use the databases to check your citations, you just walk into a library and they're like, hey, I'm going to use the computer for a bit. And they're like, not an airport. You don't need to tell us where you're going. Right. So somebody says, I wonder where there's a law library. A lot of courthouses have them. Runkle of the Bailey, good morning from Sweden. Breakfast and Runkle is a good start to my day. I need to visit Sweden sometime, and I need to try surströmming in Sweden, because I've tried surströmming in I've tried surströmming in my backyard. It was pretty good, but I kind of feel like that'd be a thing to do. All right. So specifically, Mr. Feldman explained that he drew some of his brief citations from a repository of many cases I've compiled, some of which he originally gathered during my initial research in December 2024, when I had broader access to legal databases, including case text with co-counsel. But, Mr. Feldman said, after Thomson Reuters acquired case text and integrated it into Westlaw, I discontinued my subscription due to the prohibitive cost of maintaining access. Okay. This was how Mr. Feldman excused his failure to independently verify the accuracy of citations. As a result, I was and remain unable to verify certain citations that appeared in case text searches or Westlaw-only formats, particularly during final revisions. Get your ass to the library then to check it out. So, I've never heard of a non-Swede wanting to try it again. It was actually pretty good, believe it or not. The thing is that to get a can sent to me here in Canada is it's like $150. It's very expensive. Buy surströmming online. There's a place, surströmming.com. surstroming.shop. So it's $50 for a can of Oscar's surstroming, which is sold out. I don't even know which surstroming is the best surstroming, but they have 2 surstromings for $50, and then you also have to pay shipping. What is it? For a challenge set, it's $109, and I think that's US dollars. It comes with the traditional flatbread. It comes with some Swedish candy. Okay. I mean, yeah, this other place, 3 cans of surstroming, or 1 can is $69, and that's on sale. I would eat it again. But yeah, what is surstroming? Okay, so surstroming is how do I put this? It is fish that are fermented in a can, and the can bulges because the fish that is fermenting generates gases, and those gases, and so because it's fermented, I think it's herring. Somebody said what kind of fish? It's like fermented herring in the can. So because it generates so it's got a strong odor to it. It's got a strong smell to it. And so you'll see videos online where people will take a can of surstroming and eat it in their car, which is a great way to ruin the car. But the proper way to eat it, the way I ended up eating it, is you open it in a bucket of water, and and yeah, then it doesn't spray everywhere, and yeah, and then you just have it on flatbread with potatoes and sour cream and dill. It was actually really good. And yeah, so Amazon Canada sells it at 50 to 60 bucks a tin. All right, maybe I'll give that a try. What is your favorite Old Dutch chip flavor? This one, Mexican chili. I like the Mexican chili flavor. I also like ketchup. I like salt and pepper, or salt and vinegar. Yeah. Okay. So here we go. All right. So the problem, he reiterated, was that these tools do not verify Westlaw citations and did not flag the inaccuracies. Nevertheless, and with full knowledge of these shortcomings, Mr. Feldman chose to accept suggested citation formats or assume that references matched cases in my repository without realizing they were incorrect. Mr. Feldman expressed regret for these mistakes to Mr. McMull and claimed that he would replace those citations with alternative authorities, but offered no timeline for doing so. And he asked Mr. McMull to share the list of results you compiled, a perplexing request, given that Mr. McMull's initial email had listed each erroneous citation, and to run the attached confidential brief, which he believed would correct the issues identified. I actually suspect that response might also have been ChatGPT generated, because, yeah. Mr. McMull refused to run Affable's brief, a request he and the court interpreted to be for TOP to conduct a site check of Affable's brief. Yeah, I don't do work for the other side, right? Yeah. Mr. McMull also expressed confusion at Mr. Feldman's request that he share the list of results he had already shared. Again, that probably indicates that it was AI that did it. Finally, Mr. McMull commented that while Mr. Feldman did not commit to a time by which he would correct his brief, in the spirit of what he understood to be Mr. Feldman's intention to advise the court of his conduct, Mr. McMull would provide Mr. Feldman one additional day to notify the court. Minutes after Mr. McMull sent this email, Mr. Feldman called him to continue pressing the idea that Top should review a draft of Mr. Feldman's new brief before he filed it with the court. Mr. McMull again refused. I mean, he can't. That's a conflict of interest. Like, come on. The following day, on June 24th, Mr. Feldman emailed Mr. McMull and stated that he'd already notified opposing counsel and the court that I am addressing the citation issues and will file a corrected memorandum as soon as possible. That statement was false, and I'm guessing also AI generated. That's my guess. I don't know for certain, but that would explain this. The court was first notified of Mr. Feldman's errors by Mr. McMull, June 26th letter. Also in his email, Mr. Feldman claimed to be correcting the errors in his brief, but he still refused to provide any timeline by which he would do so. In response, Mr. McMull observed that there was no evidence Mr. Feldman had ever notified the court, so he requested proof. Mr. Feldman sent back a nonsensical reply. Opposing counsel and will inform the court. Thanks for catching that. Again, probably AI. When Mr. McMull sought clarification, Mr. Feldman responded gruffly. He criticized Mr. McMull for declining to review his new draft for citation errors, while at the same time reiterating his request for help. Somewhat ironically, Mr. Feldman directed Mr. McMull to review the New York Rules of Professional Conduct. Somewhat ironically, oof. That's not where you want the court commenting on the irony. Particularly those addressing respect and courtesy among counsel. Whew. Mr. McMull rightly concluded that further communication with Mr. Feldman was not productive and submitted his letter notifying the court of Mr. Feldman's errors. The court issues an order to show cause, and Mr. Feldman responds. After reviewing Mr. McMull's letter, the court expressed its dismay that Mr. Feldman might have used a large language model to generate a brief containing citations to cases that did not exist or were plainly incorrect. Noting Mr. Feldman's professional obligation to read and confirm the existence and validity of the legal authorities on which he relied, especially when using an LLM, the court ordered Mr. Feldman to show cause by July 10th, why the brief should not be stricken from the docket and sanctions imposed on him pursuant to the rules. On July 11th, one day after the deadline, like, this guy's fucking around in every single possible way, right? Like, not only does, like, yeah, he's like, all right, I'm going to blow through my deadline and I'm going to, yeah. So the response contains 6 requests, including requests for leave to withdraw Affable's motion to dismiss papers and replace them with corrected filings, and for the court to refrain from striking the motion or imposing sanctions on Mr. Feldman. The response was also noteworthy for its conspicuously florid prose. This is where it gets even funnier. For example, it featured an extended quote from Ray Bradbury's Fahrenheit 451 and metaphors comparing legal advocacy to gardening and the leaving of indelible marks upon the clay. And it included the following passage. Your Honor, in the ancient libraries of Ashurbanipal, scribes carried their stylus as both tool and sacred trust, understanding that every mark upon clay would endure long beyond their mortal span. As the mark X in Ezekiel chapter 9 that marked the foreheads with a tab of blood and ink bear the same solemn recognition that the written word carries power to preserve or condemn, to build or destroy, and leaves an indelible mark which cannot be erased, but should be withdrawn. Let it lead others to think that these citations were correct. I have failed in that sacred trust. The errors in my memorandum, however inadvertent, have diminished the integrity of the record and the dignity of these proceedings. Like the scribes of antiquity who bore their stylus as both privilege and burden, I understand that legal authorship demands more than mere competence. It requires absolute fidelity to truth and precision in every mark upon the page. Needless to say, Mr. Feldman's overwrought metaphors and historical references raised the court's eyebrows. The court is like, the fuck is this shit? That's what the court is saying when they say it raised the court's eyebrows. It was like, The fuck? the fuck is this? Somebody says, if we covered this before? Nope, because this was just dropped a few days ago. This is just a few days ago. And somebody's saying, is it about Corey Feldman? What was Mr. Feldman's first name? Steven. It's about Steven Feldman. So not a Corey Feldman. Okay. So Flycatcher quickly opposed Affable's request to submit revised papers, which prompted Mr. Feldman to file a July 14th reply to Flycatcher's opposition that differed markedly in style from his response to the court's order to show cause. The sharp change in tenor only heightened the court's concern that Mr. Feldman was placing undue reliance on generative AI in his submissions to the court. The first paragraph is riddled with mistakes and broken prose. It is 9 lines long, but comprises just a single run-on sentence. It contains capitalization errors. It reads in full. I apologize. This is the world's worst sentence. We write in response to the July 11th letter from Plaintiffs' Counsel, which opposes defendant Affable Avenues LLC's request, inter alia, to file corrected briefing and supporting materials, inter alia, in connection with its motion to dismiss and compel arbitration, now heightened by the recent events which bring factual matters implied in the complaint to the fore in the current dealings with Amazon, which are a direct result of the factual matter presented in the complaint, which wish to arbitrate fully with Amazon and Flycatcher, and alternatively have dismissed as against it those has failed to meet the pleading standards, heightened in light of the specific allegations of criminal and illicit conduct, stolen goods, and New York Penal Law 16566, etc., upon which it bases its cause of actions with specificity as it must. What? Huh? And I can tell you, if I had a law student, like if I was hiring a junior and they put that sentence into legal filings, I'd be like, we're going to have some remedial education, and it's unfortunate that remedial education is not allowed to include violence, because that sentence made me want to violence. I so much want to violence after reading that sentence. This stark contrast between Mr. Feldman's response and the July 14th letter led the court to further scrutinize both documents, which uncovered yet another problematic citation. All right. In his response, Mr. Feldman had contrasted his conduct with the misconduct described in 2 real cases, Mata versus Avianca and Park. Mr. Feldman appeared to quote from the Mata decision, but failed to provide a pin site. Critically, unlike the pattern of deception identified in Mata, where sanctions were imposed not merely for citing fictitious cases, but for the attorney's failure to be forthcoming, withdraw the prior submissions, and continue to give legitimacy to fake cases in the subsequent submissions, despite having multiple reasons to believe the cases lacked authenticity, I immediately acknowledged the errors upon notification and undertook comprehensive corrective action within 24 hours. No, you didn't. That's why this is... in point of fact, this quote appears nowhere in Mata. A Google search revealed it to be a direct quote from an October 24, 2023 article recapping an analysis of Mata done by an attorney named Christopher F. Lyon. So, Mr. Feldman did not attribute the quote to this article. The court issued an order analyzing Mr. Feldman's recent submissions and expressing concerns about his AI misuse. The court denied Affable leave to withdraw and replace its mistake-riddled motion to dismiss documents, and it reserved decision on whether to strike Affable's brief and impose sanctions on Mr. Feldman. Instead, it scheduled a conference for Mr. Feldman to explain himself. Somebody says, what's a pin site? Pin site is a site to a specific thing, right? So, yes, and the article, somebody said read the article. Christopher F. Lyon delves into risks of ChatGPT in legal field for New York litigator. So a pin citation takes you to a specific paragraph, right? So, for instance, I might say the case of RVGTD stands for the proposition that, whatever, right? And that I might cite the case generally, right? But often you're citing a particular part of the case. And the judge doesn't want to necessarily have to hunt through 47 pages, or in some cases, 300 pages of decision, because I've cited to some 300-page decisions, and they want you to cite to like paragraph 647, which is like where the stuff you're talking about is, right? So that's a pin site, right? It's exactly here. Go here. So, all right. So they schedule a conference for him to explain himself. The court wants to hear directly from Mr. Feldman so it can give him the opportunity to, as he puts it, prove himself worthy to carry the stylus once more in service of justice and truth. The court made clear, however, that it would not tolerate further derelictions of Mr. Feldman's professional responsibilities. Mr. Feldman must know how to verify that a case exists on Westlaw without the added benefit of AI tools. He claims that, going forward, he will undertake certain remedial efforts, including inter alia, establishing database reconciliation procedures involving resolution of discrepancies through direct consultation of archival legal resources and substitution of alternative verifiable authorities where necessary. Most lawyers simply call this conducting legal research. All lawyers must know how to do it. Mr. Feldman is not excused from this professional obligation by dint of using emerging technology. So what does he do? More citation errors. So he files a proposed reply brief, and more bad news quickly followed for Mr. Feldman. Mr. McMull submitted yet another letter alerting the court to yet another citation error, this time in Mr. Feldman's proposed reply brief. So Mr. in attempting to explain why Flycatcher's claim under New York general business law failed, Mr. Feldman framed Flycatcher's argument as relying on Himmelstein versus Comcast of the DC LLC. But as Mr. McMull observed, and the court later confirmed, neither of these cases actually exists. The citation, and they list the citation, leads to a page in an opinion from the United States Court of Appeals for the Fourth Circuit affirming a criminal conviction and sentence. Whoops. The other citation, relates to a decision from the United States District Court from the District of Columbia addressing the Humane Society's application to intervene in defense of a rule redefining the statutory phrase retail pet stores, which rule was promulgated by the United States Department of Agriculture pursuant to the Federal Animal Welfare Act. The case he meant to cite is Himmelstein, McConnell, Gribben, Donahue, and Joseph, LLP, versus Matthew Bender and Company. The parties, including Mr. Feldman himself, had previously cited to it in their pre-motion letters and briefing. The court therefore found it odd that Mr. Feldman could fail to properly cite this case when he and others had successfully cited to it in earlier briefs. He attempted to explain this letter and in a letter filed in the early morning hours of August 12th, which of course worked great, and only dug himself into a deeper hole. He said that Himmelstein was a clerical error that was introduced during a final verification of the citation while double-checking and preparing the citation and table of authorities. To substantiate this, he attached a copy of the correct Himmelstein, which he claimed to have downloaded from VLEX the evening prior to submitting his reply brief. So he just keeps burying himself and burying himself and burying himself. And so they have a sanctions conference, and basically Mr. Feldman got placed under oath. It's a good hearing when the lawyers start getting placed under oath, right? And then proceeded to ask him a series of questions. While Mr. Feldman did admit to relying on AI to a degree, he failed to fully accept responsibility. His answers grew increasingly discursive and were often unresponsive or entirely unresponsive to the court's inquiries. CEG at 17, The court, sir, you are not answering my question. Mr. Feldman, I'll get to that. Sir, once again, I'm really just asking you to answer my questions. I keep asking you, and I'm not sure why you're refusing to answer me. Sir, you're not answering my question. I'm not sure how many ways I can ask it. But you're still not answering my questions, which is getting to the point of being frustrating. Mr. Feldman struggled to make eye contact with the court. I mean, I do that too, so I get it. And described an approach to legal research that was redolent of Rube Goldberg. If you don't know who Rube Goldberg is, he's famous for Rube Goldberg devices, which are devices that accomplish some sort of task by means of the world's dumbest processes. So whenever you see those machines where you've got a, you see a machine that's got like a boot that kicks a ball, that rolls down a track, that falls in a bucket, that pulls a string, that, nudges a bird, the bird chirps, and the chirp scares a monkey, and the monkey throws shit at like a tart. Like all of those things, that's a Rube Goldberg device, right? It's a machine that is intentionally complex and stupid. So, leaving the conference without clear answers, the court was left to draw its own conclusions, which it sets forth in the remainder of this section. So, basically, they find that he used a whole bunch of, bunch of AI, and it hallucinated. And we'll skip over the rest of it because it's more of him being full of shit. And I'm running out of gas, I gotta say. So what does the court do? They are punting out this. So they're sanctioning Mr. Feldman by entering default judgment as to his client, defendant Affable Avenue, LLC. So they strike the docket entries and they enter judgment in favor of plaintiffs. And McMull is ordered to submit his application for attorney's fees as to Mr. Feldman within 30 days of this opinion. I'm guessing that Mr. McMull is going to be like, I have a lot of zeros. And those zeros, you're going to turn them into money. So, man. Now, this also says that there's a thing where if I was hiring a lawyer and I found out that that lawyer was using AI, I would be firing that lawyer right immediately. And I mean, can you imagine you've got if Affable had fired the lawyer and had then said, you know what, we've fired the lawyer and we're bringing on a new lawyer. Previous lawyer filed a stupid ass filing. You should sanction him, but let our new lawyer file a new thing. The court probably would have been like, okay, all right. New lawyer can file a new motion to dismiss. We're going to throw out the old one and I will punish, counsel as I see fit. But instead they've lost and now they have to sue the lawyer. And so maybe the lives in in this town argument is to give the judge a different out versus bias being on the record. Yeah, maybe that might be, I just find that living in town is enough. It could be. And thank you for being so epic, Runkle. Thank you. I had a moment that was actually pretty cool. And Peyton Waste Miller says, streams are the best part of Monday. Thank you so much. So I walked into the bathroom at one point and the bathroom fan was on. And so there was like blowing wind and my hair did this thing where I looked into the mirror and it did the like blowing hair thing. And I was like, that is really epic. That is cool. Okay. Why can't I look like that normally? Normally I just look like a scrub. So yeah. Yeah. Kyle Aiden Fox says 1 Red Bull for Ian. So yeah, the only Red Bull I've got is sugar free and it tastes like garbage. Jan, good morning, Ian. Nice to see you're still alive. I am just wrapping up. So yeah. All right, let's yeah, it was the shampoo commercial hair. Absolutely. No fines. No fines, but there's going to be attorney's fees. And I'm guessing the attorney's fees are going to be ordered directly against Feldman. But the other thing is he's going to get sued. Like he's going to absolutely get the shit sued out of him by Affable. And he's going to have a whole lot of you know, a whole lot of cash to pay. And somebody else was saying that they didn't think I should drink a Red Bull. Yeah, Ian likely needs to sleep soon. Red Bull might be a bad idea. So here's the thing. I can chug a Red Bull and then go to sleep. And it's not a problem. Like I can just, so I mean, I'm going to probably drink another Coke before I go to bed because I can sleep on caffeine. So all right. So yeah, robot lawyers. And yeah, tangent. I just ran a Canadish animal for my property. Best guess coyote. Dog completely up on her shots, has a minor bite in the right buttocks. We're playing nurse. Any advice on repellent? 4570 repels the hell out of a coyote. Yeah, I can't show any of my recommended coyote repellents on the stream because YouTube will nuke me. But 4570 you could do it with less, but 4570 will yeah. And make sure you take that pup to a vet because you're not sure what's going on in that circumstance, and you don't want the dog to you don't want to lose your pup to to that kind of shit. So yeah. All right, we are now, holy crap, we're 5.5 hours in. I'm gonna wrap this up right away because I am completely out of gas, and I will see you guys in a bit. So good night all, and yeah, we'll just wrap it up here. Good night.